Lord's kind leave.
Certain writ appeals were filed by the respondents, my lord, and as against certain single judge judgments, my lord. Thereafter, my lord, when our writ petition was being heard, they got it to be posted before the division bench. And the division bench, again, the matters, they did not come with the office objections, so they were direct to be dealing and posted before the court, my lords. Now we are neither here nor there. So the matter came before the third court the other day. The learned division bench said, place the matter for Chief Justice, and we have made an application for directions that our matters, writ petitions, be dealing independently and heard separately. Because their matters are pending for 10 years regarding compensation.
Is to be listed before which court? You are before first court now. Don't say neither here nor there. Get it listed.
Matter
No,
pertaining
the
to
problem is this, my lord. Now my writ petitions were dealing from the writ appeal. After dealing to my lord, it was posted before the learned single judge.
Hand over your memo to learned court manager. He will see to it what is to be.
Lord's kind leave. But the Apex Court has already held that seashell is not a mineral. But the state government, my lords, is equating seashell to limestone and is insisting upon issuance of license. My lords, I have questioned that by way of a writ petition.
Withdrawing. For
I'm sorry.
withdrawal or
I have filed a petition, my lords.
then after 15. No urgency.
If my lords may permit, my lords, matter pertaining to mines, my lords, we have challenged an order passed by the revisional court, and the mining operations have been put to a standstill by virtue of the order passed by the revisional court. Matter pertains to 2022, my lords. That is the reason, my lords, to be taken up, my lords. In fact, we had moved a memo, my lords. It had not come up. The date was fixed.
No
as
urgency
19th.
where you can submit the memo after 10 days.
My lord, I filed a PIL challenging the vires of the next academic year will commence, resulting in hardship to the students
It will
who are
come.
before the court.
Without delay, it will be posted, but no memo. We will not accept any
My
memo.
lord, the date may be fixed, my lord.
We are not going to fix it. It will
Lords, it's
regularly listed. Yes.
Writ appeal, my lords. I have moved the memo on 17. My lords have directed to post it after 2 weeks, my lord. We are
What is
constructing the
it about?
cancer hospital.
What is it about?
We are constructing the cancer hospital, my lord. It's a government project. Project has been stopped, my lord.
So what is the grievance?
Our work has been stopped, my lord,
By?
by the government, my lord. Government has undertaken to stop the work without any fault of ours. My lord, please. There is an urgency, my lord.
After 15 days.
My lord, I have moved the memo on 17, my lord, please.
No. Yes. No, don't take the memo. Not to be submitted. Madam, don't take memo. Yes. Yes. Mr. Has to withdraw. Withdraw. Which one?
Not posted,
All
not
right.
yet posted today.
Complaint
Is it posted today? Not posted.
Day after two. Day after two.
My lords, with
Yes.
kind leave, state government had passed an order under section 11 of the Electricity Act because there's deficiency of supply to the state electricity grid. The learned single judge has held that state government is not the appropriate commission to decide this, and he's set aside the order of the learned single section 11 order, my lords. There's urgency, there's deficiency of electricity in the state, my lords. Hence, I've filed a writ appeal challenging the learned single judge's order.
It will be posted once you remove the office of this.
Next week, my lords.
After 10 days. Yes.
Contempt matter.
Yes.
This honorable court directed the state government to issue appointment order within a 1 month, even after lapse of 6 months. There is no contempt is. Question.
Rest. It will be listed once you remove the office of this.
One.
Yes. Then why do you mention? Once it is removed, listed within 5 days. Now we are ensuring that it is listed as far as possible. Wait. for-
Auto listing will happen.
That 2016 matter, my lord.
Sports quota matter.
Pardon? Above?
Sports
Above?
quota matter, my lordship. The KA is not consider my application, my lord, some urgency. Now petitioner are we are going to college, but admission is not confirmed, my lord. That's the reason some urgency.
After 2 weeks,
1 week will also,
no,
2 weeks, one date.
after 2, yes. Yes,
Well, at 4 acres of land, the Bangalore Center in Chamarajapete. It was donated in the year 1936 by a donor to establish veterinary hospital and veterinary concerned kennel. It is running and it's a nerve center in the Bangalore South and in the Bangalore West. Now the government has already taken a decision to close it and to give it for the minorities to build hostel for that 4 acres of land. Even earlier occasion also, the legislature has said it cannot be for the object for which it has been donated. They cannot divert it.
it can wait till it is listed.
Even office objection is complaint.
We will list it then.
But in the, because
No, except,
why
will not,
urgency is,
Ah.
these government persons, the Department of Minorities, they are taking measurement and survey of the entire land to demolish the donors building of the year 1936.
if they come to demolish, then mention again.
There is an attempt, my lord, to conduct survey and to
Let them,
demarcate.
let them have survey. When they demolish, you come again, if it is not by the time listed. Yes,
Veterinary hospital and its establishment, the functioning is now start. That's the urgency, my lord. There is about 1,500 animals and cattle.
it will listed. Let them have measurement, etc. By the time it will be listed.
Contempt
Yes.
petition, my lord, for withdrawal, my lord. Petition has rendered infructuous.
Day after tomorrow.
My lord, in 2016 matter, my lord, there is an interim order granted by this honorable court to petitioner to pay the royalty and bank guarantee.
Withdrawal matters to be listed at 2:30. Yes.
There is an interim order in this matter, my lord, within the year 2016, my lord. The petitioner directed to pay the royalty and bank guarantee to the department and take a permit and issue a permit, my lord. In 2000 February, my lord, suddenly they stopped the permit, my lord. Violation of the interim order, my lord, I permit me to file application for violation of the interim order, my lord, we have filed the application.
You remove the office objection.
Please,
See that it is listed, no acceptance of name. It will be listed within 1 week.
hearing an IA, my lord.
Wherever office objections are not, that will be listed.
There is no office objection, madam, and IA. After 15 days, my lord, any.
After 15 days,
Yes.
only, after 15 days. Yes, yes, Mr.
Lordship, it's in contempt matter. Interim order passed by the honorable court, my lord, still is not implemented. So, still is not implemented. It's in contempt matter. Any earlier,
My lord's kind leave, serial number 37.
Interim order and contempt petition.
contempt.
It will be listed. Yes.
In serial number 37, my lord, I am appearing for the response number 1 and 2. Lordship, may kindly grant me a week's time, my lord, to file statement of objections. I have intimated the petitioner's counsel.
2 weeks.
Serial number 42, my lord, 42 and 43, my lord. I appear for
42.
respond number 4.
Always, 1 week.
Please, my lord.
Serial number 42 and 43, my lord. I appear for respond number 4, my lord. We have sought for instructions from the AICT. It is yet to come, my lord. 2 weeks time may be granted.
So what do you want?
2 weeks time may be granted to file statement.
I appear for the petitioner in
Achha.
42 and 43 minutes. Minutes interim order minutes
Wait,
has
wait.
to be extended.
Yes,
minutes.
again,
42 and 43 minutes, interim order is still today.
interim order will be continued.
Obligement.
Serial number 13, my lord.
30.
13, I pray for a week's time.
Fine.
Serial number 15.
Why weeks?
Not ready, my lord, because I was out of station morning and.
Not well.
I'm not ready in the matter, my lord.
3,
13, my lord.
1, 3.
1-3, my lord.
All.
Week's time, my lord.
Serial number 15.
After vacation.
It was not even appealing for appellant. Serial number 15. So 2 weeks time may be granted.
15,
1-5.
1, 5, yes. Time,
Time.
beyond vacation. After vacation.
With my lord's kind leave. My lord, serial number 14. Serial number 14, my lord, writ appeal. My lord, if my lord could grant me time till Thursday, my lord, I have informed the learned senior counsels, Mr. Prabhuling Namadi and Professor Ravi Verma Kumar, my lord. We were not able to contact the officer.
This side or after vacation?
My lord, I told them that I would take it on Thursday. My lord may have it on Thursday.
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 Obliged, my lord.
Sorry, serial number 15. My land friend has sought adjournment. I don't have any objection. A date may be fixed.
Which one? Serial number?
Thanks.
My lords, the matter is just, my lords, have been the both 15 minutes.
You
Serial
are,
number.
you are for respondent.
Please, my lords, I'm for
How,
the
how you are aggrieved by that?
date may be. Because no back wages has been paid till today, my lords, both in spite of the order by this court, my lords. They have not paid, my lords. I have
It is
retired
no
from the
urgency,
service, my
but
lords.
in anyway, 23rd of April.
Please.
Yes, madam.
There is a disobedience of the contempt order, and today it was listed, it is showing in the system, but I don't know, the matter didn't, file didn't reach the court, Your Honor. And this 6th also, there was a date. Main accused is retiring on 31st of this month, and so the command will be now changing again.
We'll
So,
see that it is posted as early as possible.
Can it be posted today, Your Honor?
Today we can't give any date, but as soon as possible, after undergoing the necessary procedure for passing orders, we'll list it. Do you want some particular date?
Pardon, sir?
Any date you want?
As early as possible.
You are
sir.
coming from
Date
out
you want?
Tomorrow.
tomorrow, not. It is possible on next 8th.
Sir, on 6th, last month, it was, in March, it was given, but due to some technical issue, it didn't reach.
Are you appearing part in person?
Pardon, sir?
Is a 14%.
8th, next month.
Okay, sir.
You see that it is.
For the complainant.
Notice.
Complaint,
Complied with.
not
Or
complaint.
not yet complied. Not yet complied.
Notice.
Beyond it. It'll be in the week of.
For
June 10.
R3, I
You are for R3.
Petition.
Yes,
R3.
R3, I accept.
R3, learned government advocate, Mr. Great.
My lord, appearing for complainant, my lord, petitioners herein have filed a representation, my lord, seeking regularization of their service. Same came to be rejected, my lord, against the same writ petition has been filed, my lord. Said writ petition came to be allowed to consider the issue as a fresh, my lord, and with a time limit of 3 months. Despite of making several representation, my lord, same has not been considered. Hence, I'm praying to notice.
I accept for R1.
You are for first respondent.
First.
So number 3,
Okay.
Ravi HK.
In this matter, I accept
The
for
directions
R3.
issued in the writ petition are at page number 18, my lord.
Who will decide your representation?
Which is the authority who has to decide the representation?
Respondent number 2 and 3 in the writ petition, my lord.
The Mahendra will
Uh,
have for number 1.
Yes,
Notice.
yeah.
R3 for Mahindra for R3.
So number 4.
I'm for the petitioner, my lord.
Pradeep Kumar.
I'm for the petition. Lord, there is no interim stay in this matter. The Supreme Court categorically refused to grant an interim stay. In fact, I was appearing in that matter. I've been engaged as the lead counsel there. The difficulty here is, my lord, I'm unable to use my vehicle for past 2 years.
We do not know where is the direction to be complied.
My lords,
Which is the order to be complied with?
order, my lord, is at Annexure A.
Let us read it.
Against the impugned order, we have preferred SLP before the honorable.
One second. Let him satisfy the court. Where is the direction to be complied with?
Lord,
And
this
which
is
are
the final
direction-
order. This is the final order on which the SLP is sought from, my lord.
Correct, but which are the directions issued by a single judge or the bench concerned,
My lord,
which are to be complied with?
No.
We are in contempt jurisdiction.
Please. May I submit brief facts? The central government, my lord, amended Rule 47.
We want
Where is the
to know.
mandate?
Yes.
My lord, it automatically flows from the order, my lord, that once the notification by the state government says is set aside. Lord, here, my lord, notification is quashed by this honorable court. So it needless to say that it has to be complied with. Well, even here, all I'm asking is, till the matter is decided by the Supreme Court, let them extend my temporary registration at least.
Where is
Temporary
the-
registration,
We are asking you, my lord is asking you.
please.
Where is the mandate which is violated?
My lord, the mandate violated is the very notification itself. The notification is unconstitutional. That's what your lordships have held in this order. So when the notification is set aside, it needless to say that it has to be complied with. They have to grant me a registration.
That's not the unfortunate.
Then, my lord, what exactly is the relief? I fail to understand.
We also fail to understand any standard book on law of contempt would say to interfere, there has to be some mandate which is not complied with. This is how broadly,
Please.
they treat
Please.
it. We do not understand.
Kindly see the operative portion of the order of this court.
Then other things will follow.
Para 23, this is what it reads. Thus, even in the instant case, in view of the notification issued by the MORT, providing for registration of motor vehicles under BH series,
SLP is also pending.
How do you say?
SLP is also pending.
But no stay is granted.
They have not filed affidavit, Lord. It is.
no,
for
no, no,
them
no,
to
they
file
made
on
a
the last-
submission. Sorry,
Please be seated. Be seated. We'll hear.
please,
you.
please,
We'll not pass any order without hearing.
please, my lord.
The court has- The last occasion, they remained absent. There was a direction to file an affidavit and it shall be posted immediately after filing. The matter is likely to be posted on 15th April 2024.
15-4.
Yes. That may kindly peruse the last page. 4 weeks' time is granted to respondent number 245 to file counter affidavit.
He has to file counter affidavit. But where is the stay?
Stay is not granted. Stay is
For he is saying, unless it is stayed, well and good. Otherwise, pith and substance of the order has to be looked into. Relief has to be granted.
Yes,
to him, is his
understand.
worship.
We may say that there is no, you can't say.
Yes.
So there is a- As a government, you can't say they will not comply with something which is unconstitutional.
Yes.
We may say that there is no direction. So we are asking you, why should you not act in light of the order of the learned?
That since it is under consideration by the apex court.
So what he wants really, you are a private operator?
My lord, the section 43 of the Act provides for a temporary registration, whereby what has happened is
Regard
my
to
insurance has
Bharat
expired.
series registration, Lord, if the company is situated in more than one state, Lord, we issue Bharat series registration. They are seeking Bharat series, he is an employee of the private company. Our contention is that, Lord, if it is a temporary employment, this benefit cannot be extended to the private employee of the private company. Unlike public sector companies or the government employees, these employments are not permanent.
He has to file the counter. They should do something.
At least you process his case.
Temporary registration, all I ask is that.
He will process.
Because the bank is asking me to surrender the vehicle because there is no registration, why should I extend the loan? The insurance says I will not do it without a registration. Temporary registration is all I'm asking.
Not this may
Because the
be-
matter may come up before the Supreme Court, maybe 6 months from now, a year from now.
May be disposed of, Lord, with subject to the.
He will grant temporary registration.
Please.
Subject to outcome of the your SLP before the apex court.
Temporary registration.
Otherwise, he will be put to enormous, and he will not, the fruits of the successful litigation will not reach his hands.
Your Lordship may kindly have it at 2:30.
2:30.
Yes.
A pleasure.
So far as temporary registration is concerned, I seek instruction.
You ask them.
Yes.
Number 5, the Pradeep HS. And for complainant.
the operative portion of the order in internal page number 20, the respondent association not registered under the act within limit of 2 months. That is the mandate passed by the.
Cancel the registration.
Cancel registration, and they have to register the association under the 1972 Act.
Where is the mandate?
So last, in the internal page number 20, last 3 lines. Therefore, the said clause shall be read as association get themselves registered within an outer limit of 2 months from today under the 1972 Act. They have not registered the association.
Page 20.
20, last 2 lines.
I accept for R1.
R1.
In the week of 10th June.
Seal number 6, Manjunath SP.
Lord,
Yes.
page number 25. Lord,
Read the directions.
Lord,
Read the directions.
My apologies,
Lord,
Lord, in the
Wait,
last
wait,
matter.
kindly wait. Yes.
The last matter, I'm not appearing. It's not
Not-
by
no,
mistake.
We are not observing. Please read the
Yes, my
directions.
lord. Consequently, the writ petition is allowed. The impugned demand notice dated 23/12/2022 issued by the Joint Director of Town Planning, South B Bangalore, to the extent where the additional condition is imposed, calling upon the petitioner to relinquish free of cost a portion of the property measuring 2,409.9 square feet is hereby quashed and set aside. The respondent joint director competent authority is hereby directed to sanction the plan on collecting the requisite fee and without imposing the condition of relinquishment of any portion of the property belonging to the petitioner.
Yes. There is no time limit fixed for compliance. with
Time
the-
limit that, but my lord, I am a builder, my lord. My property is, I have to do.
It is the following directions contained in order dated 24th July 23 on a single judge passed in the writ petition, which are sought to be complied with. Then quote paragraph 5, page 25. On bare reading thereafter, on the bare reading of the aforesaid directions, it could be immediately seen that the time limit is not fixed while on a single judge for compliance of the directions. In that view of the matter, it could not be said that the authorities have committed any intentional or willful breach of the directions. In that, therefore, invocation of the contempt jurisdiction of this court at this stage is not well considered. At the same time, the court is of the view that the directions issued by a single judge should not go uncomplied with. The competent authority respondents therefore is directed to comply with the directions within period of 8 weeks from today. From failing which the respondents shall be exposed in contempt. The contempt application is accordingly disposed of.
Please.
The PL matter, seal number 7, the Venkatesh Prasad.
Milord, I am appearing for petitioners, Milord. Kindly annex D, page number 101. 101.
We are not here to lay the road for you.
This is a public road, village public road matter which comes under the panchayat.
Laying road is not the function of the court, Mr. Counsel.
Milord, because the road is blocked, even ambulance also not moving. They are the senior citizens and the children also not able to go to the school, and the pregnant women are not able to go to the district headquarters.
So this
hospitals.
road you are
This
saying
is
that
only one road. So there is no another alternative road
it
for
is
this.
leading
villages.
to which destination? This road which you are complaining of, that is only a mud road. Is used for what purpose?
For a traveling purpose. It is absolute necessary. It is formatted 100 years back itself. As easementary rights, they got it's circumstances and shows
So you are
that
rightly saying
they
it
are
is
continuously
essentially
using
easement.
that for the last.
For
it's a circum-
easementary right, public interest
Yes.
litigation.
No, because the road is the important, once the road is blocked, their fundamental rights are deprived, infringed, my lord. They are not able to go to school, they are not able to go to the hospital, they are not able to go to the even the temples, the pregnant women, senior citizens, everything are, because if the road, because this road is blocked, they have to round about, they have to come round about up to 27 kilometers extra. Because of that, kindly see, I am 1 minute, madam. Because I am submitting. Once the, yes, I am submitting one Google map,
My lord,
my lord, I am submitting one Google.
Please be
We
quiet.
just find out, we are not inclined to issue notice. What is the road, what is there, what is not there.
I'll do that.
We are not inclined to issue notice, but we are still asking for your satisfaction, the council, to find out what it is.
Because
No, they will come and tell the.
Please.
This
status
is,
about
this is
your
something
version.
better than rejection.
Please. As early as possible. Because the.
Next
because-
Monday, 8th.
My lord,
2
there are holidays that are there. my
2
lord,
weeks,
in
2
the-
weeks.
2 weeks. I'm
15.
And
I'm
my lord,
obliged.
1
We're
week,
going
my
to
lord.
have.
People,
In delay
people
law,
are very
but
poor
they-
people, my lord.
So we are asking the council to find out on your behalf.
Please, please.
There are a set of papers. on
Yes,
the learned
My lord, I
domain.
have. I
You have.
will do.
I given.
Obliged, my lord.
Please.
Green bench matters, still number 8, Mr. Annapurna Bodale.
Let's, I'm one of the occupant of this area for which Form B. Lords, I am one of the occupants of this area for which Form B has been issued, my lords. I've given a representation to the department saying that please look into it because we are cultivating in this area. This area could not have been notified. My lords, my representation, my lords will get it at page 98 on 26/8 to 2021. Thereafter, my lords, all the residents also have given.
How you are concerned that area should be notified or not notified as safer zone?
My lords, because my lords, we are cultivating in this,
Your residence is there.
in residents of that area, my lords. We are cultivating in that area. In fact, all the residents have given complaint that, and that was taken into consideration. That is at page 100, my lords. There also the Tahsildar has addressed a letter to senior geologist to look into it because they are all the occupants of that area has given a complaint that this area is a sensitive area.
Not appealable order. Kudi, pressure sack. Kudi. Is it not an appealable order?
My lords, of the Form B, issuance of the Form B, my lords.
It's under the Stone Crushers Act.
Section 15
Of Stone Crushers Act. Appealable order.
appealable order, but
How section is phrased,
agreed by.
aggrieved, any person.
Yes.
Yes.
Section 15.
My lords, Form C has not been yet issued, only Form B has been issued. All I'm asking is, my lords, give us an,
All orders issued by the licensing authority are appealable, made appealable
yes, my
in a
lord.
wholesale way. Very widely phrased, going by English.
Yes, my lord.
Only thing is you have to read.
Please. My lords,
Or learn it.
my lords, in that case, I may,
Either file appeal or pursue representation.
Even otherwise, there's no locus, my lord. This
Will
land
permit-
is not granted to her.
We'll permit you to pursue the representation.
yes, my
of
lords, that is good enough.
Or learned counsel, Mr. Sorensen. Counsel. Grievance sought to be voiced in this petition is against the notification dated 23/11/2020, declaring the land to be allocated to dispute number 8 and 9 as safer zone. The petitioner claims that in the zone area he is residing. The prayer is also made to set aside the certificate of compliance with the 19/20 issued by competent authority to respond 9 paragraph. Not only that, the appeal is available. Remedy of appeal is available under section 15 of the Karnataka Regulations of Stone Crushers Act 2011 against the aforesaid order, comma. The prayer made by the petitioner itself indicates that the petitioner has already made a representation to the competent authority in relation to the grievance made in the petition. Paragraph. Without expressing any opinion on the merits of the grievance of the petitioner, comma, it is left open to the petitioner either to pursue his grievance by preferring appeal under section 15 of the aforesaid act or to request the authorities to decide his representation. Most of it such request is made, the authorities shall decide the representation in accordance with law within 8 weeks.
Lord, appellate authority, there are
Either
matters.
they
competent
pursue the
authority.
representation or they appeal, whatever.
They have made a representation. Beyond that, we will not consider.
That way.
With the aforesaid observation, the petition is disposed.
Number 9, the RG called.
It's covered by the judgment.
Please, my lords, it is not a matter which is covered, my lords. I may kindly be permitted to just set out few relevant facts, my lords. Petitioner was granted a stone crusher license in Form C.
The Mahendra, you are appearing here.
The first time I am appearing.
Because license was issued valid till 31/3/39 over an area of 1 acre 20 guntas, which was declared as a safer zone by way of a notification published in the official gazette. Later on, my lords, a temporary suspension order.
And this is the second round again. Earlier also the same, you are found to be.
That is a different matter, my lords. My lords were pleased to pass a clarificatory order on the last occasion.
Very matter.
Very.
It's identical, but therein, that's a case of Sthana Pallata. But herein it is not the case. Because this 1 acre 20 gunta has been very clearly identified in the joint inspection report carried out under section 7(1). And it is
what we are saying is that earlier on 4/12/2023 also on the same ground for the same reason you were put to notice. Isn't it?
Yes, my lords. There is, yes, and an order came to be passed, my lords, at page number 87 at annexure L. Having complied all the deficiencies, I was allowed to.
8146.
Yes.
Yes. Page 87.
Page 87 is in Canaries and 89 is in English, my lords. Annexure L. Whatever deficiency that were noticed therein were complied.
Where is that order, earlier order?
No, it is by the, it is not by the honorable court, my lords.
Clear before.
It is.
You were before this court earlier.
No, my lords.
Not this.
We are not applied. We have only at the member secretary level, it was handled.
May I make a submission? No. Now the challenge is to annexure A. Annexure A is passed by the district licensing authority, against which appeal is, remedy of appeal under sections 15 is available.
That is not the correct position. At page number 25, annexure A may kindly be seen. Order has been passed by the deputy commissioner and the district magistrate in its personal capacity, not as the chairman of the district stone crushers licensing and registration authority.
Page number 26 may kindly be seen.
Page number
26.
26.
Seen Kannada Jilladhikarigalu mattu Adhyakshara.
But letterhead may kindly be seen, my lords. I might request, my lords, at page number 25.
Not even in translation, page number 30.
It's
Page
an
number
authority.
Yes, ma'am. No, what my submission is, reference may be seen, reference at number 7, 8, 9 may kindly be seen, my lords. All these references show that this office, office notice dated so and so, your representation and joint inspection. Thereafterwards, no opportunity of being heard was given, and whatever is required under the principles of natural justice has not been given. Straight away, temporary suspension order came to be passed.
Please read section 15.
Yes, my lords.
You are yet to come across another provision which would give you such a wide phraseology, giving right of appeal.
Yes.
See that
Yes,
provision.
Yes, my lord.
As
Appeals-
wide as can be.
Appeals against the orders of the licensing authority.
Who is this authority?
It is only because it must be placed before the 8-member committee. A resolution needs to be passed. Then afterwards, an order of suspension or any other orders are to be passed, my lords. It cannot be straight away, the chairman in the individual capacity or sitting alone in the absence of 7 other members can't take a decision suspending.
That can be a ground in appeal. You can't say, it purports to be an order that would fit into wide phraseology of section 15. You file appeal, so that all, we can direct, you permit you to file appeal, and we request the authority to process the appeal also.
Of course, if my lords were to say, till such time, if I am allowed to operate the query, I will file in.
That's all power of the appellate authority.
No, but in identical matters, my lords were pleased to pass an order, my lords, that is there.
Any principles have been laid down in that judgment?
No, no.
What we are bound by the principles, not that some order is passed by some judge and therefore this judge also passed the order. Generally, is not a jurisprudential argument.
I fully agree with my lords. Only thing is, an order came to be passed in 3 other identical matters. That
whether this argument that notwithstanding the appeal, we are entitled to give such a relief. Is it considered in that judgment? 3 judgments. So we have seen those judgments.
Sorry, my lords, it has not been mentioned.
Not been.
It has not been. But my lords were pleased to issue a clarificatory order on Friday, stating that only because the judgment is yet to be released, my lord.
You have seen appeal is there. Power of appeal, the apex court said, power of appeal includes power to stay the orders that have been challenged.
I fully agree. I vote on my lords. But only thing is, if an order is passed without authority of law,
that can be a ground in appeal.
The appellate authority is again a head or next immediate bureaucratic head, my lords. So where judicial interpretation.
Come with better matter.
Not this.
Come with some better case.
And then I may be allowed to permit this.
Withdraw.
My lord.
Ravindra Gajanan Kolle seeks permission to withdraw the present petition. Permission is granted. The petition is disposed of as withdrawn. Liberty is reserved for the petitioner to avail the remedy of appeal.
Please, my lord.
Such and such act. Under section 15 of the.
But a time frame, my lords.
Such appeal.
A time bound some orders.
So not filed even. You file then.
Please, my lord.
Writ appeal matters, seal number 10. Kumar JC.
Appearing
Kata proceedings,
for
my
the
lord.
government.
Kata proceedings, my lord, 11th judge, my lord, directed the parties to approach the civil court to establish their right. Lord,
boundary dispute is persisting since 1960.
But during the pendency of the
Continues to be in wholesale deeds. Certainly agree.
only one submission, my lord, contesting respondent have already approached the civil court in OS number 1286 of 2015.
Then why should we exercise?
Therefore, my lord, kindly
Testing respondent as a
my lord, after disposal of
and your party in that civil.
please, sir. Kindly time frame, my lord, one time bound, my lord, it says 2015 suit, my lord. Time bound, can directed the trial court to dispose this.
Page 27 and 28 of the order of the
If
learned
you
single
withdraw the
judge.
petition, then we'll permit you to make a request.
Please.
Learned advocate, Mr.
The only one submission.
to withdraw
After
the
the disposal of the writ petition, my lord, they have withdraw the suit and file the fresh suit, my lord. In OS number 515 of 2020.
Permission to withdraw the present petition, stating that one of the contesting respondent has already approached the civil court in relation to the controversy between the parties,
Where's number?
wherein the petitioner is also arraigned as party. Full stop. For instance, to withdraw the petition is granted, enabling the to enable the petitioner to contest his case in the suit proceedings. Full stop. At this stage, a request has been forthcoming that the court where the suit is pending may be required to dispose of the suit time bound. Full stop. No such observation can be made by the court except giving permission to the petitioner hearing to make such request before the competent court, which shall be considered by the court in light of its own calendar.
Seal number 11 to VB Ravi Shankar.
Lords, with regard to the compassionate appointment, your lords.
Is there any scheme for the compensate appointment?
There's not a scheme with the hardness in the family, your lords.
Heard learned, your senior counsel. Heard learned senior counsel, Mr. So and so. Pardon me that I am not remembering the names of all of for the petitioner. Notice returnable on 11th June.
The delay, there's a delay.
1 and 2.
There's a delay, your lords.
Let it go.
There is a delay.
Delay is there, your lords.
Delay also. Delay also notice. Learned additional government advocate, Ms. Nilofer Akbar, accepts notice.
Respond number 2. Respond number 3. 1 and 2 you are appearing. 3 Vaishali Hegde.
Learned advocate Ms. Vaishali Hegde accepts notice for respondent 3.
Seal number 12. Bindu R.
Well, I pay for the petition, Miller. What had happened, Miller, the appellant before Lordship Miller have obtained a decree against the second respondent, Miller, on by virtue of an agreement to sell. 90,000 is the arrears payable by R2. Meantime, Miller, she came to know the properties are also mortgaged by the second respondent to the bank, and the bank had brought the property to sell. At that time, Miller, there was an auction held. One Sachidananda had purchased. I intervened, Miller, in the writ petition I had filed. This honorable court, Miller, could your lordship take page ink page 62, Miller, para 4, by his 62, Miller.
Grounds.
Ink page 61. So and so learned advocate appearing on behalf of the petition in WP number 1127 submits that all the household movables, including the gold jewelry of the petition, are locked by the first respondent bank inside the house. According to the petition, she may be permitted to take out all the movables situated in the house in question, so as to enable the petitioner to sell the same and clear the dues to the bank. In other words, the petitioner wants to clear the dues of the second respondent in WP 1121, also in order to protect the property. Be that as it may, since the petition is a third party to the litigation and as she is a prospective purchaser of the property pursuant to the agreement of sale executed in favor of my landlord, petitioner is entitled to get back all her movables which are locked inside the house. I may mention the worth of jewels, silver and gold was 30 lakhs. Therefore, the first respondent bank shall deliver all the movables to the petitioner which are locked and seized by the first respondent bank within 2 weeks from this date. It's also open for the petitioner to get the matter compromised with the first respondent bank as per law by repaying all the dues. I was ready. They did not return the jewels. I had to approach this honorable court. I have approached the bank. Bank said, no, we are going to put it to an action, you participate. Then, Melad, I paid 8.5 lakhs at DD. Bank accepted the DD. And they don't permit me to bid, stating that I don't have the digital signature.
Auction also.
Auction is
participated in the auction.
Yes, I wanted to participate. I paid the 8.5 lakhs. It is lying with them only. They don't allow me. The gold is with them. The money is with them.
Now you are challenging auction itself.
Auction is held 91 lakhs. Even that I'm ready to pay, Miller. You will ask me, call up, whatever the amount due to the bank, I am ready so that I can get back my money, my property. I am ready, my lord. 91 lakhs is the action. There was a stay. I have lost money, my lord. I have lost the property. I lost my jewels.
All that happens when you do not repay the loans. When you have taken loans, your duty to repay, that's what Socrates used to say.
When we give for the amount. Actually, I have to say, my lord, if the notice is given, whatever the money liable to bank, I am ready to pay, my lord. That I pay and save my property, that's all.
You deposit the money, what is the amount payable?
Yes, my lord.
What is the amount payable?
Today also I am ready.
They're asking a question to you, simple question. What is the loan amount due?
Amount due, I am not due to the bank. Second respondent is due.
That's true, but how
Yes,
can you work out?
25 lakhs only.
No, what's your right here?
I am not liable to bank at all.
That's what your contention is.
My contention is I am liable to pay the second respondent's amount. Whatever the bank says, I am pay.
What is that amount?
There was, the amount liable was only 25 lakhs. Now auction bid is 91 lakhs. The remaining amount they want to pay back. I will bid Mela same amount I'll give. I'll give the entire amount, whatever the bank says. I will save my own property.
All right, you can save the property. What is the amount bank is likely to tell you to pay?
They want me to pay only amount due
1
was,
crore,
amount due was
10
25
lakh.
lakhs.
Bidded,
Not aware what they want.
bidded amount is 1 crore 10 lakhs.
25 lakhs was the amount due to the bank.
10 lakh 90.
I am ready. You assuming when they say 50 lakhs, I am ready to pay because I have lost everything. Any day you lost me, I am kept the money ready.
Since you have participated in the auction.
Yes.
And now subsequently you are challenging
No,
auction.
partic-
So the condition we want to impose as is for issuance of notice that you deposit the bidded amount.
Well,
bidded by the
I
successful
did
bidder.
participate. I don't say.
But you must.
But I was not allowed to bid. Because they said I don't, I am a lady. They said you don't
Generally,
have a digital signature,
Madam,
we won't permit you.
at least half a dozen judgments of the apex court will come in the way. Still, we are saying, deposit this money, then we'll consider. You can't have a free walk that way when the precedents are heavily mounted against your client. My lord has said now, show your bona fide. You make that deposit in the registry.
I will give
Then
whatever Lordship says, I am deposit.
They are saying bidded amount.
Well, your Lordship may say 50 lakhs, well, I will deposit.
it's one
Well, a bid is 91 lakhs. Even that your Lordship say, I will deposit. I will deposit, madam.
Third learned senior counsel is. Naisargi for the appellant. The challenge in this appeal is in relation to the auction, which has already taken place. The appellant was one of the participants in the auction. Although now the appellant seeks to call in question the auction on various grounds raised in the appeal memo. Paragraph in the text of the case, notice returnable on 11th June, on condition, however, that the petitioner shall deposit with the registry of this court an amount of 75 lakhs before returnable date.
Thirteen to 15 are urgent. Cell number 16, Mr. TP Muttanna.
My lord, the Regional Rural Banks Act was enacted by Parliament
Use of the mic.
Regional Rural Bank Act was enacted by the Parliament in 1976. Is a special act. As per this act, my lord, as per the notification of the government, that appellant bank, Karnataka Gramin Bank, was formed. That board of the Karnataka Bank, Gramin Bank, they formed the regulations. And my lord, the respondent number 2 was working as an assistant manager of the bank. He stole 3 crores 50 lakhs from the bank's vault. And then ultimately, after finding him guilty, he repaid the entire amount. There is no loss to the bank, my lord. Your lordship may kindly see, my lord, that annex, that page number 7 is 77 to 79, my lord. That is the provisions of Karnataka Gramin Bank Service Regulation. In that regulation, my lord, 77, my lord.
Gratuity Act is not applicable to you.
My lord.
Gratuity Act is not applicable to you.
No, applicable, my lord. That in this, my lord, this is a special act. This on the Apex Court has held, my lord, where the special act prevails over the payment of Gratuity Act. That judgment, my lord, I brought 2 judgments, my lord. 2 judgments, it says.
Pragati regulations. Is your own regulations?
Their own regulations.
Pragati regulations are your own
Their
regulations?
own
Yes, my lord.
Pragati regulations are your own regulations.
Regulation, my lord. That regulation, my lord, that 72 says.
So they are at
Regulation
variance,
72.
they are at variance with the
Statute. Are they?
Yes, that is what that Apex Court says, where there was a special act prevails over Gratuity Act. I'm producing these judgments, my lord.
So
It
you
is
mean
not a
to-
leg.
See, the wrong terminology leading to our question. Special law, it's not special act, general act.
Yes, ma'am.
Special law, general law. That way, act is only source of law. Because of your wrong terminology, wrong questions will come from our side.
My lord, this Apex Court, my lord, in the similar case and similar provision.
It requires consideration.
Hard learned advocate.
It requires consideration.
My lord, I am appearing for respondent number 2. I have some submissions to make. With respect to that Rajan and the decision, I would like to submit a list of citations.
But requires consideration
The return
because similar matter we are treating in another matter.
My lord,
19th June.
And interim order, I request. Till the next date of hearing.
The directions of learner single shall remain in stable. By way of aid entry only, it is directed that the directions of learner single shall remain in abeyance till the next date of the hearing.
December 17. Mr. Sridhar, please.
Appearing for the appellant, Mr. I request that the matter be passed over, my lords.
Pass over.
Pass over, my lords. This matter, my lord, was Mr. Holla was held up on a suite.
Pass.
Public.
This is number 18. Mr. Vijay Kumar.
For the appellant, madam. But the KHB has adopted the KCS CCA rules for its employees by Rule 5(2) of the 1964 rules. Therefore, my lord, it is the first respondent who should have received the report of the Lokaयुक्त under Section 12(3) and my lord followed the procedure prescribed under subclass 3 of Rule 14 EM.
What Gundu Rao said?
Lord?
Gundu Rao judgment, what it said?
My lord, that is not applicable because there, my lord, it is they had not adopted the CCA rules. They had their own regulations. Therefore, my lord, there was a direction in that, my lord, to act by the disciplinary authority to take action in terms of the said rules. But here, my lord, the matter is directly covered by the judgment of the coordinate bench, my lord, where it categorically held that the report has to be, my lord, first received by the first respondent government. Identical matter, my lord, arising out of the very same housing board. My lord, the coordinate bench has at para 32, my lord. But I'm reading in the next page in the middle, my lord. Having regard to the aforesaid discussion and also the judgment of the coordinate bench of this court.
There is a notice.
Requires consideration.
Please. But I had the benefit of interim order before the last single judge, my lord.
So we'll say subject to whatever the steps the inquiry officer takes.
And I'll be subjected to inquiry.
Notice it 19th June. In order to ensure that the irreversible situation is not obtained, a respondent for inquiry officer is directed to stay his ends till the next date of.
Please.
Venkatesh.
Government advocate, Ms. Nilofer, accept notice on behalf of.
One. 2 and 3 by Venkatesh Arbatti.
Arbatti.
Learned Venkatesh Arbatti accepts notice on behalf of.
3.
2 and 3?
No, only 3.
Only 3. Only 2.
Review petitions, seal number 19, Mr. H.V. Sundareshan, party in person. H.V. Sundareshan, party in person.
Learned party in person is not present when the review petition was called out. It shall be next listed on 11th June. The party in person shall be intimated by the registry about the next date of posting.
Seal number 20, Mr. T. N. Vishwanath.
And for the petitioner, my lord, in this matter, my lord, petitioner's husband was an ex-serviceman. My lord, sorry, my lord. And 7 acres, out of 7 acres, 6 acres was granted in the year 1975. And thereafterwards, the first respondent, Mariappa, also claims to be the grantee. And his claim has been negatived by the revenue authorities.
You were not party to the proceeding.
Not party.
Then avail Shivdev Singh versus, sorry, 63 Supreme Court.
Please, my lords, but one judgment of the Supreme Court, please, my lords.
Shivdev Singh follow ಮಾಡಿ ನಾನು ಹೊರಳೆ ಸಾಹೇಬರ judgment ಬರ್ತಿದ್ದೆ before the same judge. 63 Supreme Court Constitution Bench judgment says, where an order has been made without you being a party, you nominate to the proceeding, you should go before the same judge.
If I am an
by filing the writ petition, we have taken that view. We have about a dozen judgments of that kind. Following another judgment of Justice Swami Bench, 19, ILR 91, Karnataka. Have you seen that Shivdev Singh judgment?
May I seek short accommodation? May I seek short accommodation?
Law is well settled.
Yeah, this is what, my lord. Just,
63 Supreme Court. It were to be latest law, we would have given you a lot of time. That judgment was taught in every law school. This is for what proposition?
No, with regard to review, aggrieved party can maintain a review petition. That's
We have considered this judgment also, since that learned single judge already having invested lot of time, after seeing the judgment, something will come to his mind. Oh, this is the way. You are not a party. You avail that judgment. That's how we have
Also-
structured our judgments.
File to leave to appeal.
Not necessary.
Leave to, you can file leave to appeal. Where is the question of filing review appeal?
I've already filed,
Then
sorry, my lord. But
you can file leave to appeal against
But
this.
writ appeal has been dismissed, my lord. That is the reason, my lord. Government has filed a writ appeal. That is the reason, my lord, I'm before this honorable court, my
We are
lord.
not a party to that.
I'm not a party, I'm aggrieved party, my lord, because they have suppressed the material and they placed a overruled judgment before this honorable court. That is what, your lordship may kindly see this judgment, please, my lords. Murugaraj,
Can a person who is not a party, you nominate, maintain a review petition?
Yes, my lord.
It's already spoken. Which is that?
any aggrieved party, provision is also very clear, my lord.
47.
Please, my lord.
What if EPC code? A non-party can maintain a
Yes,
review.
any aggrieved party can maintain, my lord. Application, any person considering himself aggrieved,
Not necessarily party.
not necessarily a party. But why I am filing this review petition, my lords? Because the in this also, in this judgment,
But read subsection 2 of order, rule 2 of order
a
47.
party who is not appealing from a decree or order may apply for a review of a judgment notwithstanding the pendency of appeal by some other party except where the ground of such appeal is common to the applicant. And appellant, or when being respondent, he can present to the appellate court the case in which applies to the review. Here is a case where writ appeal has been dismissed.
You mean to say the first provision employs the expression any person considering
Any person
aggrieved.
aggrieved.
The second uses the phrase a party who is not appealing.
But
But then,
correct, my
Mr.
lord.
Counsel, why you are choosing the review jurisdiction
Why?
as against the appellate jurisdiction?
No, because
You
my
can file
submission,
leave to-
my
leave to-
submission, my lords,
Leave to appeal also,
once,
where the area of consideration will be wider.
that's true, my lord, but here is a case where, my lord, government has filed a writ appeal against the order of the learned single judge, my lord, that has been dismissed. So I have no remedy, because suppose if I file a writ or something, so that's automatically, I cannot take any shelter under this. That is one aspect, my lord. Second aspect is, my lord, overruled judgment has been placed before this honorable court while submitting, because may pass on, Murugarajendra Swami's judgment has been overruled. That is,
Rajendra Swami, which is
yes,
that Swami?
division bench ruling may pass on this.
Of which year?
This is of year 2000, 1986, my lord, this is 1986.
86, that is Murugarajendra.
Yes, the lordship has observed in that judgment, and now may pass. The other judgment, full bench judgment may pass on this.
That Guru Raja,
This is
is Babu's judgment.
not, my lord, the one.
Justice Babu Mirde and
No, no, it's lordship Justice Mohan Shantan Gowda Bhaktavasala and Justice Bhaktavasala and Srinivas Gauramal, full bench judgment. Last para may kindly be seen, my lord. Last para, page number. Last para, last page, my lord. Backside, my lord. Backside. At Supra, it is held that the law laid down by the division bench of this court in Murugarajendra Mahaswami's case is not correct. Further, the law laid down in Mallayagowda's case that after the stage of appeal under section 136(2) of the Land Revenue Act, a person who is aggrieved of the order made by appellate authority has to necessarily approach the civil court, and there is no remedy of revision as against the order of the appellate authority is also not correct. Accordingly, we
The review applicant seeks to review the judgment and order dated 22nd January 24 of the division bench, passed in writ appeal number 1013 of 23. by submitting that even though the applicant was not a party, the said proceedings, review at the instance of the applicant would be maintainable in view of the phraseology employed in order 47 rule 1 of the Code of Civil Procedure 1908. Full stop. Since the aforesaid submission was made, the court is inclined to examine the same. Full stop. Therefore, notice returnable on as 22nd.
Make one submission, not
22nd April.
4 days delay is there, but direction has been issued by the Honorable Court to enter the name of the first respondent in revenue entries because series of
No,
litigation.
with condoning delay, how we can make any interim order? I have seen that Sri Uttaradi Mutt versus
I
Sri
know.
Raghavendra Mutt Swami.
Please.
You are citing so many Swami's judgment nowadays.
Not under blood. This Honorable Court judgment blood. Date. May know the date. 22nd.
Four to seven.
Regarding non-compliance of non-compliance in contempt matters, seal number 21.
I appear for the respondent. Filing complaints of citizen.
You have complied with the order now?
Yes.
Compliance
Last
is by
occasion-
rejection or by favoring the litigant?
Not, they are entitled for new pension scheme is what the endorsement is. The last occasion, university also filed.
I've already filed.
Direction is to consider their representation. We have considered and passed a detailed out.
Lord, I just issued the copy now. Lord, I just issued the copy.
You have received the copy now?
Your lordship may consider granting me 1 week time because I look into it. Please, please. Next week, any date. Please.
After vacation, immediately we'll have that.
Date may be given. May I request your date, ma'am? Please.
Seal number 22. M. Krishnappa.
In this matter, we have filed complaints.
Complied.
My respectful submission is there is no compliance, my lord.
This is
I am
slightly different, Lord, because
I am filing my objections to the compliance affidavit. There is no compliance at all is my respectful submission. Not compliant.
What is the compliance, brother?
Lord, the direction is to allow them to conduct their activities in accordance with law. Lord, in the guise of allowing women employees, they wanted to conduct live band activities in the sense, Lord, the music is played in live and the girls would dance to the band.
Whether
that is not.
Dancing is prohibited by law?
Lord, that leads to illegal activities without permission, without taking permission of such activities. Lord.
Which is the law which prescribes permission?
Under police.
Police Act. Padi. Which provision?
Police Act.
The statement is not, we are not, disturbing the activities.
The law is settled. A free citizen is entitled to do everything which the law has not prohibited.
Yes.
A legal person can do only such things which the law provides for it. That's the law.
Yes.
Which law says a girl should not dance? And Nataraja statue finds a place in the constitution.
No, it is not only dancing,
Which
dancing
law?
with objectionable attires, Lord.
Which law? We'll call this matter some other day, just come with after
Tomorrow.
Free citizen to do governed by statute. Some circular, something like that.
Right to move freely.
Right to dance, free expression.
Something reasonably.
Point of view.
Which day do you want?
Next week. No?
Reopen, after you.
The date may be.
30th. Number 23.
That's I appear for
PA
the,
Kulkarni.
that's I appear for the accused. That's I'm making a statement that that's within making a statement that within 3 weeks that's a positive compliance will be reported on that. The issue here is that that's we have to consider the complainant's representation within a time bound manner. That's we had certain difficulties because we can't do it ourselves. We had to take approvals from the social welfare department. Now that we've got it, there would be a positive compliance within a matter of 3 weeks from today.
But you can't make the free citizen to come to court
That's-
again
we
and
apologize
again.
for
That's not
that.
the object of constitutionalism.
Yes.
How many times they should come to the court? They have a better job to do. It's not a happy place. Court is not that happy place.
I would only request.
Will
for
be
that.
complying with the order.
Yes,
Within what period you will be?
3 weeks, on that undertaking, I request.
Since 1996, I am fighting this litigation. On 16/2, your lordships wanted the compliance, positive compliance on 16/2. After 16/2, another 2 months are over now.
That's very do it. We've just got.
And he is asking again 3 weeks time.
He's saying that he is assuring positive
2
things.
weeks may kindly be granted, and before vacation, 1 date may be given. That will solve the problem.
There's only one difficulty. We'll comply, We'll comply, signed with the liberty, if
Lord
we
is
don't.
asking, within what period? When are you going to come? We
3
are not
weeks.
on assurances. We have been disappointed like anything by the assurance of the state entities. Therefore,
3
tell
weeks.
us which date, outright
3
date.
weeks from today,
3 weeks.
Yes,
Regard to the directions issued by learners and judges in order dated 27 March. Respect to grant of promotion. Promotion.
Yes.
The complaint from a learner data written by Statutory for the state pollution control. Makes a state. Complied within 3 weeks from
today.
the above statement will satisfy the complainant appealing to learner.
May kindly be relisted before vacation.
Aggravated contempt.
Yes, my lords.
Grateful.
For 24, Sri Sriram Reddy.
This matter, my lord,
Simple.
4 weeks time. may
Very
be-
simple. We will comply within
My
4
lord.
weeks.
My
4
lord, one
weeks time may be
submission, my lord.
granted, will comply.
We'll comply with.
Yes.
My lord, one submission.
Same order.
Even before filing the complaints, kindly direct Tahsildar and additional register to conduct the survey of 1 acre of land. I am a widow.
No, they are saying within 2 weeks, they are complying with this order.
Before that, at least they conduct the survey.
Within 15 days.
No,
What's
they
the
are
urgency?
conducting
Any
the
heavens
survey,
are falling
survey
down.
for other lands. Kindly go through page number 18, my lord.
We come after reading all papers.
Conduct Podi and Durasti work as expeditiously as possible within a period of 3 months. It is almost 1.5 years.
It is some order regarding 40 and 40.
And it was placed before missing file reconstruction committee. There was an order passed. Lord, within 4 weeks, Lord will complete entire.
Comply that.
The directions,
40 and Durasti.
40 and Durasti.
the directions contained in the judgment and order of learned single judge dated 16th August 22 relate to conducting 40 and Durasti work by the competent authority of the respondents after affording opportunity of hearing to the complainant to be done within 3 months as directed. Full stop. When the present contempt proceedings come up for consideration, learned government advocate Mr. S.S. Mahindra makes a statement upon the instructions of the competent authority that the authority shall comply with the directions within 4 weeks from today. This statement satisfies the complainant appearing through so and so, learned so and so. In view of above, the contempt proceedings are closed and disposed of. Non-compliance of the direction and the non-abiding of the statement by the council shall expose the authorities to the aggravated form.
Number 25,
Date, my lord.
Gopal BV.
Kindly give the date.
Date, no date now.
I'm for against 1 and 2 in this matter, my lord. I'll be filing complaints affidavit, the registered.
You will comply with the order.
I already complied, I'll file.
You complied also. Have you shared a copy?
No.
Okay, as well, sir.
Consideration. You have considered now. What way? In favor of the citizen or against him?
Because it is.
I'll go through this.
In his
judgment.
favor.
Maybe hard, Your Honor. I will go through this.
What is go through? Contempt is
just
a
give me
matter
the-
between court and.
Just received it here.
On
They have
date-
said we have complied with and they have placed the material on record.
And not this order was passed on the 23rd of September 2023.
In your favor only.
6 weeks they were required to comply with the order.
All
I
right.
gave a reply
Time-
and they didn't reply.
Time in our country, we don't stick to the clock when we are launching the satellites, we do that, not when complying the order of the court.
What learned single judge directed in his order dated 25th July 23 was to decide the representation of the petitioner dated 22/9/21 within stipulated time, paragraph. At the time of hearing of the contempt proceedings today, learned advocate Mr. So and so for the respondent stated that the representation is decided and thereby the directions are complied with. Full stop. The factum of compliance accordingly could not be disputed by learned advocate Mr. So and so since he was served copy with the decision on the representation. Also, the contempt proceedings are closed and disposed.
Deeply obliged.
Your favor it is.
Deeply obliged.
Mr. Vice. Number 26, Mr. Sagar.
For the complaints counsel.
For the accused number 2, your
Annexure C1, my lord, page 44 is the order. The operative portion is on page 46. Lord, after hearing me, my lord, your lordship was to my lord, the director, that's right, to find my lord objections.
Interim order. Interim order.
There's an interim order.
We are not entertaining the contempt against interim.
Despite the interim order, my lord, the illegal construction is going on.
Maybe either you withdraw or you invite order. Choice is yours.
Your lordship may kindly permit me to pursue.
Learn it.
Work out before the same judge.
Withdrawing?
Yes.
Learned advocate, Mr. Johnson, 6 permission to withdraw the present contempt proceedings in light of the fact that they are directed against the interim order. Full stop. It will be open for the complainant to approach the same court where the main proceedings are pending to work out his rights and remedies in accordance with law, disposed of according.
I am told that before the learned signatures brought the respondent accused have given an undertaking that they will not comply with the orders passed by the Honorable Court. They should also may kindly say one word.
We do not know anything about the proceedings of learned.
We haven't that way in the series of judgments.
This is number 27, Mr. Bairegoda.
27, Lord, in this matter, I am filing complaints of counter affidavit. This is a matter wherein, Lord, we have to place the
Committee for
application
regularization.
before the unauthorized application.
Committee is not.
Similar, committee is not passed. Similar orders are passed in CCC 14 of 2023, passed on 28/3/2023.
So in other matter, you made a statement that within 4 weeks from the date of
Yes, sir.
constitution. of-
Yes.
Page number 22, there is 2 months time is granted to the committee for forming a committee. They're not till done, you know.
Committee has to, the way, in similar matters, we have taken a particular. view.
Second-
CCC
This is
14
second,
of 2023.
this is second round repetition, second round contempt of lordship. They're not.
Dated 28/3/2004.
That is reasonable. Once the committee is constituted, they will decide for the case. Following what the directions contained in the judgment.
Liberty to
and order of
revival
law and a
the-
single judge.
Liberty revival the.
Permit us to complete the order dated 27th January 23 and quote paragraph 7, page 8. Full stop. Thus, the direction is with regard to deciding the application of the petitioner with regard to the regularization of the unauthorized construction, unauthorized occupation. The decision is to be taken by the committee for regularization. Full stop. It was stated by learned paragraph. Government advocate Mr. Mahindra that the committee for regularization of the unauthorized occupation is yet not constituted and not functional. He, however, made a statement that within 4 weeks from the date of constitution of such committee, the grievance of the petitioner will be attended to and the directions will be complied with by deciding his application. Full stop. In view of the above statement, the court does not see any further any reason to continue with the contempt proceedings. Full stop. The respondent authority shall abide by the statement made by the council. Contempt proceedings are closed at this stage.
Liberty
At
to
this
revival
stage.
of the petitioner. If not complied, liberty to revival of the.
At this stage. Again, you can come.
Liberty to revival of the decision.
This is number 28. Vignesh, where are you?
For the complaints. Operative portion is a 13 million.
To the respond, I have filed wakalat on behalf of the accused number 1, but I require some time, Lord, to, Lord, here's a case where I have been directed to pay compensation to the complainant. Lord, whether that land has been actually utilized or whether we will be giving up the land, Lord, that is what was under consideration. Lordship may grant me 4 weeks time, Lord, by then we will survey it and
2 weeks after vacation.
after, please.
Request of learned advocate, Mr. So and so.
No,
To
before
the
vacation.
respondent, stand over to 11th June.
Please.
In the meanwhile, do something.
Yes.
Number 29. Chidanand P.
The lordships kindly, my lords, I appear for the accused number 1. We have preferred an appeal calling in question the very order of which contempt is being complained now. That is to be listed on the 5th of this month, my lords, that is this week. 5th of this month, 5/4/2024, because we've moved it also because contempt was filed. My lords, the appeal number is 44 of 2024.
Since it was stated that
This
Writ appeal
contempt
number-
petition may be connected with
Tagged
that.
tagged
writ
along,
appeal.
tagged along, tagged along.
it was stated that the writ appeal number 44 of 24 arising out of the very order brought under the contempt jurisdiction is going to be listed on 5th of
5th of April, my lords.
the present proceedings shall also be listed along with.
Please,
the same
deeply
date.
obliged, deeply obliged.
Seal number 30, Adi Narayanappa.
My lords, I appear for the accused number 3, my lords. I filed my wakalat before the register this morning, my lords. Short accommodation may be given to file the reply.
After vacation, 12th June.
Hearing on interlocutory applications, seal number 31. Mr. Ganpati Bhatt.
This is that matter, my lord, pertaining to that deemed extension. Whether extension of the period is is a renewal of lease or not. Whether there is automatic extension, that is
That's only.
rule 6, 1 clause 1, that way.
May I take your lordship to section 5,
Or 0,
5.
5. What?
Section 5 of Karnataka Regulation of Stone Crushers Act 2011.
The deeming provision, my lord, one judgment of Justice Venkatramaya as he then was, of course, that. Because he quotes it from Lord the House of Lords judgment.
Lord Atkins' judgment.
Yes. If my lords come to my lord,
Let us see the sections now. First. Yes, Mahendra.
A license shall be valid for 20 years and may be renewed for a further period of 10 years, subject to fulfillment of the conditions laid down under this act or the rules made thereunder. And it is not a blanket extension. It is subject to fulfillment of the conditions laid down under this act or the rules made thereunder. Lord, now
What is meant by this?
Lord,
What is when section will be applicable?
Lord, this section, this deemed, this period, extension of period, it is not deemed extension. It is meant for a period of 20 years. It is stated in the section that all the a license shall be valid for 20 years. If I am going to issue a license today, it shall be for 20 years.
Correct.
20 years. Then, Lord, 5(1) comes to play. 5(2). Subject to payment of annual regulation fee as may be prescribed. All existing crusher leases, crusher license granted before the commencement of Karnataka Stone Crusher Regulation Amendment Act 2020 shall be deemed to have been granted for a period of 20 years. This is for the existing leases as on the date of the Amendment Act came into play. Then, Lord, the benefit of extension under subsection 2 shall also apply. 1, 2, there are 2 categories. Lord, before that, I would like to take your lordships to section 4. Section 4 may kindly be seen. Because section 4 is not amended.
Yeah.
every application for grant or renewal of license to carry on business of stone crusher under this act shall be made to the licensing authority in such form, in such manner, accompanied by such documents and such fee as may be prescribed. An application for renewal of license shall be made to the licensing authority 3 months prior to expiry of the license.
What does it say?
Blood,
It speaks of what events? The section is, the building blocks of the section are grant or renewal. It's not a case of grant or renewal.
It is.
Why?
Blood, the word used in 5.3 is renewal. Renewal application shall be filed because this lease was expired prior to 2020.
Which 5?
5.3.
Why you travel to 5.3 at all? Also, see the intent of the legislature. There is identical, almost identical discussion by Aaron Barak of Israeli Supreme Court. He is considered to be reincarnate of Justice Holmes. In his purposive construction of law, he says, we need not travel to other provisions where the legislature intends to grant additional benefit at all. Kindly see, come to subsection 2. Other day, my lord was saying, they constitute separate classes only. Kindly see the intent of the legislature is to exclude intervention of the officers. It's not a case of grant, nor a case of renewal of the lease. It is because grant and renewal, lease is an extension of contract which will involve two parties. Here, no party is involved. The king is doing this. Caesar wants to do that. Every deed will be extended like that. Where you are doing with the intervention of the party by contract, etc. Then that question arises. Now, please listen to us. So I'm making something after making lot of reading. See, subsection 2 speaks of statutory extension of lease periods, not by act of parties. It is by act of the legislature, though not of the God. The legislature says the period stands elongated. True. Number 1. In what all cases? Other day my lord was saying, all they constitute 3 different classes only. In what all cases? In cases where an application which fits into 2, subsection 2 of section 5. Then we go to subsection 3. See the terminology chosen by the legislature. Also, therefore, there is another class. We need not travel to that at all. This is submission.
My submission is class 2 of section 5. Subsection 2 of section 5 is not applicable to the present case for this reason. The license was expired in the year 2018. It was not in existence as on the date of Amendment Act came into force. Not in existence. They have filed renewal application. That came to be rejected. Yes. 3.2. 3.2. Yes. For the leases where licensing authority has rejected renewal application solely on the ground of non-filing of such application 3 months prior to expiry of such license, but has applied for renewal before the expiry of license, as stipulated under subsection 1, the renewal under subclause 2 shall be subject to payment of penalty of rupees 2 lakh.
Will not fall.
Will not fall.
Will not
First,
fall.
2 it will come. Subsection 2. See how subsection, you applied for extension, you admitted other day, we remember, that application for extension was filed 1 month anterior to the expiry of the lease.
That's true.
So, application for renewal is filed 1 month before the expiry of the lease.
Yes.
Then it fills into 5.2. Reads 5.2 again.
Subject to payment of annual regulation.
That payment they have to make.
Yes.
Yes.
All existing crusher licenses licenses granted before the commencement. Existing, the word used is existing.
It had expired.
That was expired
When?
in the year 2018.
18. And they applied when? Then this came into force in 20.
20. And it is covered by the judgment of this honorable court. I am placing it. This very section has been
Same
interpreted.
judgment you cited in some other matter, same, Justice Oak.
Justice Oka Sahib's.
Yes.
So existing denotes the current state of affairs.
No, my lord. Please look at 3.1. What applies is 3.1. Please look at 3.1. 6.3.1. Benefit of extension under subsection 2 of this.
531.
Yes, my lord. The benefit of extension under subsection 2, my lord, that is automatic subsection 2 of this section shall also apply for cases where the crusher license renewal application was filed before the expiry of such license, which is pending consideration before the licensing authority. This is what will apply to us. My application, my lord, before expiry, my lord, I had filed that application for renewal. That, my lord, was pending. Therefore, my lord, subsection 2 will squarely apply.
So your application before the expiry of license,
Yes.
period.
Yes, my lord.
Otherwise.
I
this will
admit.
lose,
I admit. Class 2 of subsection 3 of section 5 is applicable to the present case. However, Lord, his renewal application has been rejected. Lord, you'll ask me kindly go back.
Not rejected, my lord, with the greatest respect.
It
my
was
lord.
pending. Is it
Pending.
rejected?
Rejected.
When?
I'm producing that Form D also. Form D was issued, rejection was issued
Yeah, I agree.
on 16/3/22. That was not challenged before this honorable court. It is based on the proceedings dated 16/3/22.
Get it to us, my lord. I don't know this.
The proceedings, they have challenged before the revisional authority.
Perhaps Valla has not been told about that.
Please, I think he is not appraised of.
It was rejected on which date, brother?
Rejected on Lord.
Let us have the foundational facts. Sir. Lease is of 22/10/2018 for a period of 5 years. Correct? Not correct. It appears to be correct.
Expired on 22/11/2018.
That's what. It was granted on it expired on 22/10/2018.
18.
It was for a period of 5 years. The application was made on?
Application was made subsequently.
No, brother. 22/10/2018 is the date which other day Valla said, and we have noted also.
2000.
Then 5 years, that will be 21/10/2022. 23.
Seeking for 5 years.
Huh?
Seeking
For a 5 years, extension of 5 years. So a renewal application was filed.
Filed, that was rejected.
That was rejected on which date?
On, in the year 2022, I'll tell you. On 16/3/2022.
16/3/2023.
22. Based on the proceedings of the licensing authority dated 16/3/22.
And that was challenged in revision?
No, my lord.
Revision, yes.
Not challenged, challenged also.
Annexure R.
Kept pending. Challenge.
That is impugned here in this petition.
That is revision under 53.
15, section.
But appeal.
Appeal.
Proceedings while attending. Proceedings.
Then it fished to 3-2, 5-3-2.
3-2.
But that is now, that also you have not done. 3-5-3-2. Please come.
Please.
Even going by your version, subject to what Mr. Valla will say. Please see the terminology of 5-2-3.
Please.
For the cases where the licensing authority has rejected renewal applications solely on the ground of non-filing of such application 3 months prior to expiry of such license, but has applied for renewal before the expiry of license as stipulated in subsection 1.
Thirtieth March 2020.
It's
We
an
had not
automatic.
rejected it.
Assuming
That's
that
what
they
I
have
wanted to
rejected.
say that.
Still cheap. It will fit into 3.
No,
Both ways.
Both ways.
Therefore, both ways.
Both ways.
On the date of coming into force, the amended provision.
It was not rejected.
It was not rejected.
it was not rejected.
Then it makes your case worse, sir.
No, no, that's why I
When we
would
come
like
to
to
5.3,
take,
because we'll be laying down, we are by your interpretation. Ultimately, what we interpret is law. You have this in your mind.
please,
5.3.2.
please.
Read 5.3.2.
For
The
the case,
terminology, you have to, how we are going to, the building blocks of the section, which Holmes would used to say, to
rejection for the reason that
It was filed.
It was not filed.
Filed within 3 months.
3 months
Anterior
prior
to expiry.
3 months prior to expiry. But 1 month prior to expiry, if they file with a fine, that shall be accepted is the intent. May I take your lordship to section 4. Section 4 is relevant for this reason, because it speaks of renewal application. 4.
Speaks of 3 months anterior to expiry.
Anterior in provisos. Subsection 2 of 4. On receipt of application for grant or renewal of license, the licensing authority shall cause joint inspection of the location under subsection 3 of section 6. It contemplates, my lord, joint inspection as provided under subsection 3 of section 6. It is the declaration of safer zone, even for renewal application.
Correct. Correct.
A requirement of this safer zone notification is there.
It is for extension. In other words, the going by the terminology of section 4 and section 4A, 5, including 6. If we go by that, renewal is as good as a fresh grant only. Some benefits are there. Entire process will not be. But so far as this is concerned, the entire exercise, when you grant, also will be done under 4.2. Correct.
But even post 2020 amendment, this section 4 is not amended. It remained intact.
Correct.
It remained intact. That
Correct.
is to say, not even in case of extension, where deemed extension, where renewal application is filed, this exercise of conducting joint inspection contemplated under subsection 3 of section 6 has to be done. Is my submission.
Question is whether that should be done or not is the question before us.
It is, Lord, because the rejection is on the ground that this crusher is situated within 45 meters from the major district road. That is based on that, Lord, fact it has been rejected. Now may I take your lordships to the judgment which I have placed. The very section has been interpreted. Page number 31, Lord, it starts. In this case, Lord, the Act 2020 was challenged. Virus of Act 2020 was challenged.
Common cause.
Not second judgment.
Second judgment. That R. Anjaneya Reddy.
Anjaneya Reddy was state Karnataka.
But this amendment was not there when this judgment was rendered.
This is the very, in this writ petition, the virus of 2020 was challenged.
2020 rules. Amendment.
2020 amendment.
To the Act.
To the Act. The very amendment was challenged. May I take your lordship straight away to para 26, page number 54. Before that, from 23, I may be permitted to read. That is also. Subsection 2 of section, last page number 52, para 23. 52. Running page number 52.
Yes.
Para 20.
Subsection 2 of section.
Subsection 2 of section 5, added by amendment, creates legal fiction by providing that subject to payment of such annual regulation fee as may be prescribed, all existing crush license granted before the commencement of the Amendment Act shall be deemed to have been granted for a period of 20 years from the date of original grant. Thus, by deeming fiction, the period of the license subsisting on 30th March 2020 has been made 20 years instead of 5 years. There are no averment made to show that the deemed extension of the period of license is manifestly arbitrary, etc. Then, Lord, by the Amendment Act, Section 5 has been amended to provide for license period 20 years. By adding subsection 2 to subsection 5 by the Amendment Act, the benefit of extension of the license period to 20 years has been extended to the subsisting licenses. Subsection 2 of section 5 brings on par the person who are holding license as on 30th March 2020 with those who apply for license from 31st March 2020 onwards, by providing that even existing license will be entitled to be total license period of 20 years. There is nothing arbitrary about the subsection 2 of section 5.
Don't you go to paragraph 26, which supports your argument?
Yes, 26 support. The application for renewal of license are governed by subsection 2 of section 4. For all purposes, the said application are treated as application for grant of fresh license. Both class 1 and class 2 of subsection 3 of subsection 5 refers to renewal applications. There are no exception carved out to subsection 2 of section 4 in respect of applications covered by class 1 and class 2 of subsection 3 of section 5. Even the renewal application covered by clause 1 and 2 of subsection 3 of section 5 will be governed by the procedure provided in subsection 2 of section 4. Therefore, before the benefit as per the subsection 2 of section 5 is granted on renewal applications covered under clause 1 and clause 2 of subsection 3 of section 5, the exercise of joint survey for declaration of safer zone as contemplated by subsection 2 of section 4, read with section 6, will have to be undertaken only after all the conditions, including condition of site being the safer zone, are fulfilled. While renewing the license, effect will have to be given to subsection 2 of section 5. Therefore, we find that there is no harm.
Does it really help you?
Yes.
It's a case of renewal.
Does it help you? In what way it helps?
It helps, my lord, because
merely it says that the section 5 amended will be subject to or to. But you can carry out the survey in terms of section 4.
6-2 exercise has to be done. That is what my submission is. We have conducted 6-2 exercise and found that this
will it automatically take away the right to get the license extended? Your right to undertake the survey, etc., under section 4(2) is kept intact. But will it automatically, straightway, without anything else, take away the right of the party to get the license extended as per the amended provision?
No.
Legislature wants extension. Why it wants, we do not know. That's not our inquiry, scope of inquiry. Legislature says 5 years becomes 20 years. 20 years becomes 100 years. It is the legislative wisdom. We are interpreting the provisions. We are not manhandling the provisions to suit an argument of the government side, because government is not the author of these provisions. It's the legislature. Legislature says X, Y, Z factors are present in a case. Alpha, beta, gamma will be the result. That is the purpose of deeming. What is to be deemed? The period to be deemed to have been elongated. Nothing beyond that. If you were to, and my lord pointed out, go for exercise under 4.2 also. Who prevents you?
6.2 excess.
No, 6.2 no. Because 5.253 do not admit there has to be a separate exercise under 6.2. 4.2 we can understand. Because there are
What is the ground of your rejection? What is the
rejection ground is what?
What is your ground?
Ground is, it is not in the safer zone. The crusher is not in the safer.
So that is done, that is the decision arrived after undertaking
4.2.
I may be permitted to place similar rejection order.
Rejection is not on the ground that before expiry of 3 months.
No, that's not on.
That's not the ground.
Was not challenged. Only proceedings of the licensing authority was challenged before in appeal. And appellate.
So Mr. Holla, they can reject the benefit of automatic extension only on the ground if something is found out upon survey under 4.2, and that is what it is found out.
Lord, can I persuade your lordship, just look at my lord section 5, subsection 2.
Thing is found out against you, that is not in safer zone. If 4.2 has to be read with the amended provision.
Safer zone has already been declared. They have not, my lord, they cancelled the safer zone. Please come to my lord.
That is during earlier
Please
period.
permit me to say whatever I want to say. I've already said, please permit me to say what I'm saying.
Yes, please.
Learned my lord Chief Justice asked me something, please.
We'll hear
Some
you
courtesy.
again.
Please come to my lord the safer zone.
Here.
At my lord running page 37.
Of your petition.
Yes, my lord. 19/1, Maidala, my lord, English translation, my lords get that at page 38.
Page?
38. Please come to my lord, running page 39. Maidala is my lord, the area, my survey number. And this is a notification issued by the Office of the Director of Mines and Geology, setting out, my lord, this safer zone. They have not, my lord, cancelled this. Now, my lord, if your lordships come now in the light of that, please come to my lord running page. Sorry, section 5.2.
Mr. Holla, we have not I have not understood. Please come to annexure C.
Yes.
Yes.
This is, my lord, a safer zone, my lord, under the regulations. They are required to, my lord, identify safer zones in terms of the, initially, my lord, of the Supreme Court of India judgment. Thereafter, my lord, pursuant. Pursuant to, my lord, the very act, my lord, which was enacted in furtherance of the orders of the Honorable Supreme Court of India.
So which is your
19/1, Maidala, my lord, page 39, 7, serial number 7. Tumkuru, Maidala, 19/1.
This is for what period?
My lord, there is no period, my lord, mentioned.
It continues.
Yes.
Indefinitely.
Yes.
So you are going reviewing the area of safer zone. At what period? At what interval?
This was initially for a period of 3 years.
Where is that?
Not there.
That is the case of the petition.
That's all right. You have to show it from the notification.
Notification, not this was issued, not then the existing rule was only 3 years period crusher license was issued.
License all right. This is not a license. This is a earmarking particular villages as available for crushing activity.
No, no, in this.
Section says this notification is valid for a period of 3 years. By argument, it cannot be. They may argue so many things. You also. But question is, law decides the longevity of this notification. Which section says the notification issued under this section shall be valid only for a period of 3 years, 4 years, 5 years, as the case may be.
No section contemplates.
Then you cannot restrict it. You cannot restrict it.
No, under
What
4.2, I can restrict.
4.2.
4.2, because for every new renewal,
Even this notification in currency,
no, it is not in currency.
that you have to show us,
That's what.
that you have to show us that this was time bound or for limited period.
This cannot be time bound. If intention of the law was that the notification issued under this section should be for a particular period, it would have either authorized the government to fix the period or law itself would have prescribed the period, as it has done in so many provisions under this act.
So for declaring safer zone, is there any section, rules which provide the time?
6.2. 6.2 is the rule.
time
It doesn't,
time-
period is
that's
not
what-
proper.
Then once that notification is
Is
issued,
it your policy to undertake the exercise periodically?
Yes, Lord,
Where is
whenever,
that?
4.2.
Show something to us that this has the restricted operation.
Lord, 4.2 makes it clear. Lord.
In terms of time period.
Section 4.2 makes it very clear.
or two.
4.2. On receipt of application for grant of renewal of license, the licensing authority shall cause joint inspection of the location under section 3 of subsection 6. That is the section for declaring safer zone. After declaring safer zone, the licensing authority shall issue
So at
certificate.
the time of every renewal application,
Please,
you undertake an exercise
exit.
to find out that whether that unit is in the safer zone. Even if it was in the safer zone earlier by way of notice.
It will be, by logic, it has to be in the safer zone only. You cannot issue notice for a unit which is not within the parameters of safer zone at all.
My submission is, it was expired in the year 2018. Suppose one temple or a school is constructed near the particular proposed area, or if it was missed out, some road is missed out in the earlier notification, we are entitled to conduct a fresh inspection and declare it as a safer zone. If it is in the safer zone, we'll issue license. Otherwise not.
Can you make further research?
Yes, that.
Can you make further research on to substantiate your point? Please, we appreciate what you are arguing. Still, there is nothing that convincing. Where is this order 16,322? 16,322 whereby you rejected the renewal. It is on record?
Yes, now I have placed on record. First document is blood. The proceedings dated 16/3/22. It starts from page number 2. Translation is at 6. May I read blood? Column number 15 in page number 6. Lordship have it.
And your page 38 notification was issued about which provision?
6-2.
6(2).
6(2). 6(2).
Who is the authority to issue that notification prescribing
License.
these villages are open for crushing activities?
Licensing authority issues the notification. The joint inspection will be conducted by Forest, Revenue, and Mines and Geology Department.
No, these 8 villages are enlisted, na? The
Yes, yes.
notification which you mentioned. That notification is issued by which authority?
Deputy Commissioner, my lord, please come to my lord, section 8.
Same authority.
Same.
Deputy Commissioner of the district.
Same
Superintendent of-
authority is issuing that.
Yes, yes.
Now, the complaints of the villagers are subsequent. That is all right. Now, even if you are right in your submission, and even if this exercise leads to a conclusion which you are submitting,
Yes.
are you not supposed to vary this notification by excluding this particular?
Place, that
Place.
area.
As a consequence, you need to issue a consequential notification or not?
Yes.
Modifying this
Earlier notification.
earlier.
Earlier notification. Yes, it has to be.
Because that, once it is issued, it continues still rescinded.
Either it is removal of anomaly or ironing out the creases. We do not know.
Yeah, a fresh notification ought to have been issued.
That has not been issued.
Not been issued because it will not satisfy the conditions contemplated under subsection 2 of section 6. The notification will be issued only if it satisfies the conditions specified under subsection 2 of section 6.
Fresh notification.
Yes.
Curtailing the period of earlier notification or modifying the earlier notification.
For any notification under 6(2). Say for zone notification under 6.
We want you to still do the research. Do not
Yes.
conclude the anything.
Still pendulum is on the other side.
Last may have it any day.
16.
And before that, Lord, I would like to draw your lordship's kind attention to common cause judgment also. It is in respect of lease where deemed fiction has been.
So in course of the discussion, we have adverted ourselves to the advisory jury.
That I have produced. That's the first judgment I have produced.
Deeming has to be given full effect.
That is the
Is
another.
the law. Unless you show it otherwise.
In the common
Can't
cause
say we deem
judgments.
only half and then we leave the things open.
Yes. I'll convince you, because in common cause judgment, conditions.
Let us see.
April.
16th
Seal number 32.
Lordship.
I appear for
May
impleading applicant.
but
We have
we'll
made
come
an
to that.
application for impleadment in this petition.
Your Lordship, if I may.
We are the scheduled castes and scheduled tribes of Kodagu district. The original inhabitants were widely.
But
We'll hear you also.
Please. So my application may be allowed
My-
because I
my-
like to file my objections to the petition.
You are in support of the petition.
No, we
No.
are opposing the petition.
Opposite.
We are opposing the petition. Because we will be ousted from the district if the prayers are granted. We are the original inhabitants of the district, constituting about 30% of the.
Your Lordship, if he listens to me, my prayer is very clear. We are not asking anything except,
I have raised.
the
preliminary
prayer is, we are
objections.
not asking anything specific except that a commissioner inquiry be set up and the matter be undertaken. May I read it? Issue a writ of mandamus or any other writ directing the respondents to formulate, execute a commission under the monitoring of this honorable court
to consider the legitimate and rightful demands of the CNC and the internal political self-determination rights under the Constitution of India. Now, before the commission, they can make these submissions, and all the implementers can go there and make these submissions. It is basically in order to clarify the issues which have been raised, because now we have also been directed by this honorable court to make the Ministry of Tribal Affairs also to be brought in. And hence, this is probably the last we will have of any, because all other tribal elements have got what they want under 244. So therefore, this one has been there for some time, and it needs to be there to consider, and particularly since it was at one stage a complete state by itself with a very distinguished people, but they are a distinctive group, they are a tribal group, and they need to be given the facilities which the tribal groups are given in the Constitution.
By asking for geopolitical autonomy, you mean the statehood?
Separate statehood.
No, within the state, that is also stated very clearly.
Lord, I have raised preliminary objections regarding maintainability of this petition, locus of the petition.
Therefore, we are asking Mr. Swami that whether it means
No.
granting full-fledged statehood or not.
Not at all.
Prayers,
We have said it very clearly within
whether such a prayer
within
can
the
be granted.
Constitution of India.
Is seeking mandamus.
No, all that we are
Maybe-
praying is
maybe
our
there's a-
application may be
maybe
allowed.
this is,
We'll come on record, we'll file our objections. We are ready to address the matter on merits.
This can be done in the
And
coming.
court can-
State has filed a comprehensive objections, Lord, your allotment.
But in the pleadings, they are seeking the relief of recognizing themselves as scheduled tribe persons.
No, they are
No, no, no.
seeking to constitute a commission to recognize them.
Formation.
Sir, Dr. Malin's case has already decided the courts have no jurisdiction to go into the question whether X should be considered as a scheduled tribe or scheduled caste.
Let us see, because immediately by granting this prayer,
Yeah.
no injury will be caused to your client.
It will be
Only
caused.
when
It will be caused for the simple reason. We are tribes already living in the district.
We are not saying anything. His prayer is, we are yet to consider, his prayer is.
No, all that I am
kindly
praying
see
is.
Formation of the commission.
No, with
that-
with due
And a
respect.
commission-
No, no,
and a
no.
commission
Our
can
applications,
consider everything.
our applications may be allowed. We will file our objections.
That exercise has been already come to. Lord, we have filed, they have.
Let us see, let us see. Let him-
Sir,
Mr.
6
Swami,
months
let
ago,
us
I
see.
filed the application. Till this day, no objections are filed. So kindly allow my applications.
No, my petition
I'll
had to
file
be
my
amended,
objection to the writ
bring in
petition.
the Ministry of.
Who are you?
We are the original inhabitants of Kodagu district. The scheduled castes and scheduled tribes of Kodagu district. We constitute about 30% of the population. We are vitally affected by the
Commission can look into that also.
Mr. Kamath and Mr. Mahendra are on this same platform.
Yes.
Kamath maintains the equidistance from perhaps.
We are saying that the petition is not maintainable.
because there are several such claims. Court may kindly take note of them. Belgaum, there is a claim by Marathas claiming a similar relief. Originally a princely state,
Part C state.
Part C,
Part C state.
Part C state,
Like Kutch.
Kutch.
Ah, right,
Yes.
After reorganization of states, it was merged. One of the 5 parts that were merged in the new state of Mysore.
So again, you are seeking statehood. Part C
No, there's no statehood at all. Absolutely.
Part C itself is about.
Only commission, and the commission can decide anything they want, subject to the, it is after all going to be monitored by the court. There's no question of another state. It's a issue is that, as in other cases, they should be within the state, have certain privileges which a tribal body needs, or tribal associations need to further them. In fact, your lordship, if I may refer to your brother, honorable judge, there was a Kodava matter which had come before you. I don't know whether you remember.
I
In
remember.
which you said, give backward class.
Every word in that judgment I remember.
That is pending before the Honorable Supreme Court.
That's all right. It is, but we are right now with the High Court. How can you suddenly dismiss it and say?
It is SLP 002925.
Anything can be pending in the Supreme
That issue
Court.
is pending.
The
before
issue is that these are matters that need to be discussed
Court of-
in a cool manner outside the court. And the commission is the obvious place to do it. And that's all we are suggesting. We are not suggesting either this or that, or binding the commission in any other way.
this way.
Division bench, after a single judge's order, division bench affirmed the judgment.
Yes.
Prayer was of similar nature.
Now, they were claiming ethnic right to carry firearms.
Ethnic right to carry on firearms.
Firearms.
No, that's
the
a
benefit,
miss.
no. No, sir.
Your lordship, this is not the way.
No.
If you have
No,
a
that was the
prejudice
sub-
against
that
them,
that was the substance
against the
of the matter.
Kodavas, please don't say these things.
It was.
They are only on certain occasions, they bring
Writ
out.
petition was
And that is
against their
and
right to carry arms.
women of the society there, they are the ones who take the gun around. It's only in festival occasions. There's no demand at all that they should be allowed to carry weapons around. Absolutely not. So these are the propaganda that has been going on against the Kodavas.
Bring into your prayer. About the constitution. It's not necessary to coordinate some statutory framework. You to raise your grievance on some statutory framework. Which is that statutory framework on the basis of which you can plead
These
and
things.
seek the prayer.
You,
Like to be addressed.
yes, you may give me some time for that. We'll file an affidavit and
Factual aspects we may go through pleading. But for a commission to be constituted by
Which
the
law?
court- by the courts order, there has to be.
So legal framework is
legal
necessary.
framework on
I-
which
I-
we can pass law.
certainly we will
Statement of
expect.
I may say
objection,
so,
I raised
even
the
that
first
issue
round.
is covered by a judgment. of-
Yes, your Lordship, kindly peruse the para 2 of my statement of objection.
If I may refer to Article 244, the
Para 2,
24A.
page number 2. Petitioner herein has existing right. Neither have the petitioner substantiated the respective statute or provisions of Constitution of India which entails
There might
any
not be-
legitimate.
There might not be a statute directly governing the thing. But for a prayer of appointment of commission to be granted and to be constituted by court's order, what are the statutory things to be satisfied by all of us,
Yes.
not only by the petitioner? So that we would like to be enlightened.
We'll file an affidavit on that.
The Commissions of Inquiry Act 1952 is the only act.
That is
which-
what, that is what indirectly.
It is not a justiciable issue at all. No, nobody can demand a commission to be
So
constituted.
this might travel in the realm of the Commission of Inquiry Act also.
Yes, 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 1952 Act.
So those parameters we have to be considered. In light of the special facts, of course.
So therefore, my application may kindly be allowed. I'll file my objections to the matter may be heard anytime.
Yes.
They have not filed any objections. 6 months are over.
If this is to be commenced today, then we may commence and will be heard.
Yes.
If it is to be postponed to any another date, if the petitioner wants, then whatever
Very good.
suits all of you.
We can
Very good.
grant a short date. I'll be pleased to come before the vacation.
But
Impleadment application.
impleading application, Dr. Swami,
Yes.
impleading application we can allow so that he also, it will have matter because it's a PIL
Yes.
and there will be a greater audience. All
As-
cross sections of
as you're-
people, all that way it appears that.
We welcome that and we have no objection.
So we'll grant, pass the order.
There's also an application by Kodo Samaj Milords, IA number 1, which is for impleading Kodo Samaj in this particular matter as petition
You
number 3.
also want to be impleaded,
Petitioner number 3.
whatever Samaj.
Please, Milords.
Dr. Swami, there is another application.
Yes. And
How many impleading
But he
applications?
is supporting, that's why he's on this
No, we
side.
do not know. In the PIL, there is nothing like supporting or opposing at all.
Well, he's,
Every-
like
see, he's
partition
saying more or
suits it.
less the same thing
Same.
that I'm saying.
We need not ask whether to be granted.
I beg your pardon, Your Lordship.
Pass the order in both the.
No objection.
Next date would be
The
also subsequently known or?
No, whichever suits all of you.
Because they have to file objections. Now they are
I'll,
parties.
we'll file our objections.
The maintainability issue may be kept open, like we have taken.
All, everything is open.
Open, we are not closing.
Ninth of
19th is,
29th of May.
29th of May, yes, absolutely.
Could it be 1
It
week
happens to be my
later?
wife's birthday, but that's all right.
Could it be 1 week later? We don't want to deny our learned friend the pleasure of celebrating the birthday of his.
Is it a birthday?
1 week later, that will suit us.
Is it the
also.
birthday?
29th of May.
Oh,
Happens to
29th is
be
all
his
right.
wife's birthday.
Then we'll not,
29th is all right.
then we'll not keep, we'll not trouble you.
No. 29th is all right.
No, Professor wants.
1 week, 1 week
1
later.
week more,
1 week.
okay. So,
1 week.
1 week.
yes, in fact, the election results will be also out and
5th of
there'll be
June,
less tension in the country.
5th of June,
Very well.
5th of.
Obliged.
Petitioner has
obliged,
to amend
Your
the
Honor.
cast title. Petitioner has to amend the cast title. because we are
Yes.
allowing those applications.
Completing
We'll
4 to
undertake
8 will be response.
2F.
The name of the council was not shown properly. The spelling of Please.
Spelling correct ಆಗಿ ಬರಿಬೇಕು.
obliged.
One small thing we wanted to know,
Please.
can government constitute commission, the body of the kind which Dr. Swami has prayed for? The Horse 1952 Act. Commissioner.
244A.
Sir, the field
So
is,
independent of that act, also that power exists.
the field is occupied by the commissions of inquiry. So therefore, they will have to come within the,
Occupied field.
yes, it's an occupied.
So we are parallelly legislating if there is a parallel path.
If there is.
We'll examine the matter.
Ah,
I will examine.
Much obliged.
This is loud
Yes,
thinking.
Number 33. With the HR Renuka.
Since I appeared before the render single judge, I was asked to take notice. I received instructions, I filed wakalat, short accomplished.
After.
Well,
Cell number 34. To P. Vachan.
For the government, my lord.
Appear, my lord, for the appellate in 34, my lord.
Recalling.
4/7/2023.
One of the- Read it over. So IA number 1 of 20.
Donation of the 2 is format orders.
The prayer is made by the applicant appellant to condone the delay of 86 days which has occurred in filing the application for restoration of the writ appeal. The appeal appears to have been disposed of for want of compliance of the, for want of non-removal of, for want of removal of office of license. It is stated that several documents which were required to be translated could not be supplied within time. As a result of it, the time limit for the removal of office of license could not be complied. It was submitted that the translation and typing were consumed lot of time, therefore time elapsed before the restoration application could be filed, leading to delay of 86 days. Very good. The reasons stated are bona fide. Sufficient cause is made out, delay is gone down. Application is allowed. Then other application is for recalling. It's 2 of 23. Or learned counsel for respective parties. This application is filed seeking to recall the order dated 10/3/23, whereby the writ appeal can be dismissed for want of removal of office of this. The ground urged is that the documents were required to be typed out and translated, which consumed time, and hence office of decision could not be complied with in time. Paragraph, it is to be noted that the delay in filing the restoration application has been gone down by passing order of even date. Paragraph. Learned advocate for the applicant submitted that whatever office objections are left out shall be removed now within a period of 2 weeks.
Please, Madam.
From today. In view of this assurance and in view of the fact that the applicant should be permitted to contest this case on merits rather than being thrown out on technical ground of removal of non-removal of office objections. Present interim application is granted. The writ appeal paragraph is restored to its original file. Subject to condition, however, that the office objections left out to be removed shall now be removed within 2 weeks from.
Please, Madam. Lordship may kindly fix a date in the matter, Madam. Lordships may kindly fix a date in the matter, anytime after the vacation also.
After vacation, 6th of May, 6th of June.
My lord, before vacation, my lord, would be appropriate, my lord.
What is it about?
Lord, it is a BDA acquisition matter. My lord, my lord, there is a delay of 1 year, my lord, in filing the writ appeal. There is a delay of 1,110 days in filing the writ appeal, my lord. Therefore, my lord, I would submit, and they have given us an NOC also, my lord, saying that, my lord, they will not go on appeal, and that, my lord, we can proceed with the land.
Immediately after this.
Date maybe. Date might be.
6th of June.
Oblige, my lord.
See number 35, Anand KR.
My lords, I beg to appear for the appellant in this matter. Early hearing application IA 1/24. I beg to appear for the appellants, my lord. IA 1/24 is filed by Mr. Nayak appearing for the respondent. A date may be fixed, my lord. I will appear in.
After vacation.
Immediately after vacation.
In the meantime, my lord, may kindly order for fetching the documents from the TCR from the labor court, my lord. If my lords may be pleased to.
Record shall be called from?
The labor court bank.
From the labor.
So as to
Labor
reach
court bank.
this court on or before the next date of posting, stand over to 28th June.
23 days delay is there, we can condone that delay.
Condone.
I have
Days
not.
condone.
I have not.
Delay of 23 days condone as sufficient cause is made out from the averments made in the supporting affidavit.
Grateful, my lord.
This number 36. Basuraj Karedi.
I appear for the petitioner, my lord. This is a public interest litigation filed challenging the allotment of 3 CA sites to respondent number 5 by respondent number 2, my lords, on the ground that the CA sites which are earmarked for particular purpose have been now merged together and allotted for construction of a community center.
When that happened?
If my lords may have.
We're only asking you when it happened.
My lord?
When that happened?
My lord, in 2020, the lease was executed in favor of order was passed by the DC respondent number 2, which we came to know only in 23 when the construction began in the area, my lord. Annexed B is the order passed by the DC directing respondent number 3 to allot the site to respondent number 5, my lord.
Where is the document to show that these sites were earmarked for CA activity?
Please, my lord. Page number 24, annexure A. Is the map, my lord. The sites in question are the 3 sites which are right over the park, which are earmarked for dispensary, post office, and primary school, my lord.
Requires consideration because of Apex Court 2018 judgment.
Please.
Your Lordship, in this case, I got instruction from respondent 3 to file wakalat on their behalf, not research Okil.
You appear
Pray
for-
for short accommodation. Respondent 3, Lordship.
Changing the purpose.
Yes.
Third learned advocate Miss
Preeti Kareddy.
Nidhi
Preeti.
for the petitioner, notice returnable on 21st June.
My lord, notice is
1, 2.
Notice already?
already issued in the matter. I am,
On behalf of
To appear
respondent 3,
for
on respondent 3.
all the respondents have come on
File
record.
wakalat.
I am appearing
I'll undertake.
number 4.
Then file, they want to file reply. Objection.
Please.
Well, objection, you are appearing from Dapur.
No, my one Mr. Shivkumar Tingle is the panel advocate. Along with him, I am filing wakalat. Next year I'll file wakalat.
My lord, in the interim, my lord, may there be stay of construction.
Completed now. What is the stage of the building now?
I am told 2 floors have come up, my lord.
Then let us see. We will
My lord,
detail
at-
the floors also. In the
May
event
there
it
be a,
succeeds.
may the construction be subject to the outcome of this petition, my lord.
Construction started.
Yes.
Please, my lord.
2 floors. It already constructed. also.
Construction of what?
Samudaya Bhavan, my lord, community center
It was originally earmarked for what?
for dispensary, post office, and primary school, my lord.
Public purpose. Nature of the Bio. Interim relief.
I am for
After hearing all the learned all the sites come up, by of interim relief, it is directed that the constructions which may be put up on the land in question shall remain subject to outcome of the petition.
Oblige.
Number 38. Pradyumna L. Narasimha.
My lords, in this
Follow
matter, I
through.
appear for the appellant. My lords, this is a matter which pertains to the judgment of the learned single judge in WP 2852, my lords, of 2022. My lords, this is a judgment where the appellant corporation's family pension scheme, my lords, was the bone of contention. And my lords, the learned single judge has made the ruling that the appellant corporation's family pension scheme effectively has an arbitrary cutoff date, my lords. My lords, what was also alleged by the petitioners in the writ petition was that the actual government order was also arbitrary. However, my lords, without making any finding on that aspect, the learned single judge has only interfered insofar as the appellant corporation's memo is concerned. Now, my lords, with this, the actual impugned judgment, my lords, relies on the judgment of the Honorable Supreme Court, in this case called All Manipur's Pensioners Association, my lords. And that is the sole reliance which is placed. This, my lords, is a decision which follows from the Honorable Supreme Court judgment in DS Nakara. Now, my lords, the decision in All Manipur Pensioners Association has been questioned and placed before a bench of the Supreme Court by the Supreme Court in this case called the State of Himachal Pradesh versus KP Nair. My lords, I had placed the judgment before this bench.
Financial stakes by implications of this judgment, financial implications.
My lords, the financial implications, my lords, we have filed an affidavit. My lords will have the affidavit. This is filed on the 27th of February, my lords. The financial implications are severe, my lords, if I may say so.
How much?
Because effectively, my lords, it is approximately 250 crores because these are effectively all family pensioners will be affected by this judgment. My lords, there are two difficulties which arise because of this judgment, my lords. The first is that all family pensioners which the appellant corporation pays family pension to, they are affected by this judgment, which is unaffected. The government order which the appellant corporation follows in all cases, my lords, for payment of pension is unaffected. However, my lords, the learned single judges only interfered with the appellant corporation's memo. Now, my lords, if there is no difficulty or there is no finding of any interference with respect to the GO, my lords, our submission is that interference only with respect to the appellant corporation's memo is therefore was never called for. And my lords, the second submission, and this is the crucial point of law, my lords, is that DS Nakara as well as the All Manipur Pensioners Association judgment have both been whittled down and they have subsequently watered down, my lords, the ratio itself. Here, my lords, is a case where there is no arbitrary cutoff date. My lords, this is a case where there is no arbitrary cutoff date, and therefore, it is a case which requires consideration, my lords. This is an appeal which has not been admitted as on date, my lords.
You are for original petition.
Please, my lords, after the original petitions.
Nakara view is diluted to a great extent in the
Please, my
subsequent judgments.
My lords, but it's a decision of the Constitution Bench of the Supreme Court.
It
my
is
lords.
watered down.
That is one aspect, my lords. The second aspect, my lords, kindly see the affidavit that they have filed regarding financial implications. They simply say 250 crores without substantiating it. My lords, your lordships may take my word that I'm not asking for arrears. Whether this includes arrears or future payment, they do not make that distinction. They don't produce a scrap of paper.
If arrears are given up, how much it will be a hole in your pocket? To what extent?
My lords, on that aspect, my lords, I'll have to seek instructions because this is, my lords, this has been made insofar as the actual payment that is made to the family pensioners are concerned, and then it has been my lords, it is then expanded because all of the family pensioners of the corporation, that's what we have done, my lords.
Simple arithmetics. Simple arithmetics at the 8th or 9th level. How much money the corporation, the appellant corporation is going to shell out in the event they agree that arrears they will waive? That you have to state in your affidavit. You have said it nebulous nebulum, assuming that they will not waive at all. If they waive, what is the hole in your pocket? That you have to say. It's one of the factors. Financial constraints, financial aspects are considered to be one of the factors in deciding the cutoff date.
Please, my lords, the affidavit that we filed so far was filed, my lords, insofar as everything is concerned. So if they are to then waive off the arrears, we can then seek instructions on that aspect. But my lords, the point of law that is there in this case, my lords, deserves consideration, my lords. The appeal currently is not admitted. And that is why we believe, my lords, that on admission, my lords, I would strongly make the submission that this needs to be admitted, my lords.
My lords, in fact, they didn't contest before the learned single judge, my lords. The corporation did not contest, neither did the government.
Employees retired or expired between 1/7/2005 and 31/3/6. The revised pension, family pension shall be fixed notional. So which is the class who?
I am before 1/7/2005.
Before.
Please. That is the cutoff date. And prior to the cutoff date, I don't have the benefit of the liberalized pension scheme. My lords, in the liberalized pension scheme, they enhanced it by 30%. But the base salary that they took changed. My lords,
enhancing 30% on a smaller base will not put me on the same line as enhancing 30% on a larger base. Therefore, I'm on the aspect that the base has to be the same for all, irrespective of the cutoff date. The base salaries, of course, will be based on their last drawn salaries.
Please, my lords. And effectively, my lords, this is where the distinction arises. So, my lords, ours is one. Please, my lords.
Just find out the financial burden if the arrears are to be foregone.
Please, my lords, we'll do that.
Difference of the
My lords,
Financial amount you have to say.
These are essentially widows, my lords. They are really in a poor situation. One of them is getting 3,000 as family pension, my lords. It's very difficult in this day and age to.
My lords, that is, my lords, as we have pointed out in the appeal itself, my lords, they are, every payment that is made currently is commensurate to current rates, my lords. This idea that they are being paid less, my lords, is actually incorrect. And we have produced a table to that effect, my lords, of what is the current payment to each of these family pensioners who are before the court. But my lords, on the financial aspect, my lords, I will seek instructions. My lords may just give me some time because, my lords, it is effectively voluminous records, my lords. These are over 1,000 family pensioners, my lords, who are similarly placed.
Second, we are keeping.
22nd of April.
Very well, very well. I'm deeply.
My lords, grateful.
Number 39. Now CN.
Serial number 39, may I request for a passover, my lord? I
appear
appear
for
for
appellants in
KPP,
serial
sir.
number 39.5.
Don't pass over.
No, my lord.
Please, my
I
lord, sir.
appear for
I request.
appellants in serial number 39.5. I said.
But last time there was a direction to produce that expert report that we have. My lord. I appear for the examination authority. That report, my lord, is in a seal cover.
Wrong key answers and.
Yes, no, there are
that
two.
matter.
It comes down to actually two key answers, which the examination authority has found to be.
Totally 3 to 4 questions that were corrected by the KEA in its revised.
Three.
Any urgency?
Urgency is this, my lord,
The
sir.
selection process is at stake for the petitioners at least.
My lords, pursuant to the interim order, my lords, appointment orders have
On
already been
7th
issued.
February.
This is that 100. 100 is already appointed. The rest, my lord, is balance is, my lord, another 50. 50. There are 15 or 16. No, total number.
55 appellants.
55 appellants. So that many
100
100 vacancies are there.
Vacancies
Vacancies are
may be there, but we.
You can accommodate them also.
Yes, ma'am.
As per, my lord, the original list, it was 501 who qualified with the 35 marks. Upon, my lord, the change that occurred, it became 636. So it went up. Therefore, my lord, if there are sufficient number of posts to cover that, then this issue becomes a non-issue.
That's what.
That KPTCL, my lord, has to.
KPTCL has to.
Please, my lord,
specify
I
last
appear
week
for
motion
the-
there.
My lord, sir.
You are for KPTCL.
for the KPC. Mr. Nagaran will appear in this matter, my lord. He is on his legs.
How many posts?
So may I request,
No,
for a
if we can
passover.
accommodate everybody, then things
Uh,
will, of course,
My lords,
simple.
please, my lord. My lords, the problem, my lords, is that all of these posts have a reservation in quota as well as Hyderabad, Karnataka, non-Hyderabad, Karnataka quotas. So, my lords, we have to examine whether these operation of this, these petitioners fall within the quota of the remaining seats. And with regard to physically handicapped quota, we cannot convert them to any other post, my lord. So
We
that
can't make out
examination,
what you are arguing, therefore we always
Please.
request to come in
I
person so
apologize.
that
I
your
apologize.
clients will get justice. Otherwise, if you say
apologize.
something, we will say some other thing, we'll, whatever order, we will write and leave the things as they are. Because we have no option. If the lawyers come and argue, we will be able to do. Otherwise, we argued like this, we feel we're not impressed and we dismiss that. That way we'll do the orders.
I'm told, my lord, that the number of posts are much more than the number of candidates now.
Posts are,
Posts are
vacancies
much
are
more.
available. But some statement, official statement has to
Has
be
come
made
from
by the
KPTCL.
employer,
KPTCL.
potential
Yes.
employer.
I request for a pass-over, my lord.
Fact, my lords, that has been recorded in the order of this court. My lords.
Council is, they don't take interest in coming.
My lords,
to court.
I request for a pass-over, my lords. I apologize, my lord.
The APTCL went ahead, my lord, and appointed, my lord, the other posts on the basis of the revisory key answers. This is one, yes, sir. This is only with regard to assistant engineer electrical. One respond number 3 filed writ petition and the learned single judge quashed the entire.
My lords, according to the statement they have made on 7th February 2024, there were total 501 posts, which this one.
No, that goes up to 600 and odd now.
Yes,
501 selected.
And what they have appointed is only, my lords, 404.
So another
Still
100 posts is
vacancies are
available.
there.
Still vacancies are available.
Yes, and my lords, in the revised key answers, we are shown as meritorious. Whether we are meritorious or not is the question. That is answered by the KEA.
That's the main issue, whether a second revision is permissible in law or not is the issue. That's covered by several judgments.
The question is this, my lords, if the experts say that the first list was wrong, nobody can.
Revision of the key answers repeatedly. When the first of the notification says this is the only process and then end of.
Ultimately, whether anyone has.
Lords, KPTCL could give a quietus
They
to the
could be
matter if they
appointed, my lord,
respond.
subject to the outcome of the writ appeal, as they have done in respect of others.
No, once appointment happens, then sending them back will create lot many problems. It will,
Well, so my lords may, if necessary.
The second.
Please. Third point, case though.
The question is only this, my lords. They say that second revision was not, review was not permissible. My answer is that whether anybody has got a vested right in perpetuating the mistakes.
13 June. 13 June.
13th of June.
Should we file this report now or should we keep it with us? The expert committee report, which is the last order which was passed by my lords.
Ultimately, my lord, on the basis of that report, the answers have revised.
He answers.
You can share copies of, there is nothing secret in that.
You can share it. I don't see.
It might minimize the area of
dispute also.
Yeah, it's an expert report, Lord, on 2 or 3 questions, that's all.
learned senior and in the first stated that the expert committee report.
Master teachers' names.
Experts pursuant to the directions of this report is available.
Yes, ma'am. Maybe be permitted to mask the names of the experts, my lord.
In the sealed cover.
No, it's there in sealed cover, but if you're just allowing them to see it, maybe
Well,
mask
they
the
can,
names.
they can not, they need not disclose the names of the experts. Because that is the view taken by the
Be
Supreme
another
Court
level
also.
of arguments on that.
Because thereafter,
So on that day,
We can look it.
on that day,
On that day, ma'am. Very well, we'll hand it to on that day. Sir.
the same shall remain in sealed cover.
Yes.
So
So then what we'll do is we'll leave.
The same was directed to be opened
Blocking their names, they can give copies to us.
in the presence of learned advocates for all the sites. Report was shown to the court. So as far as supplying of the copy of the report to the contesting parties, same shall be supplied without disclosing the name of the experts of the experts.
I'm grateful.
One writ appeal has not been connected with this batch. If it could be.
You share copies, please.
We'll
masking-
hand over copies.
Masking names
Mas-
of
yes,
the
that will-
experts.
that will-
My lords, in the meanwhile, could the KPTCL,
Those are the objections, my lord, that cannot be. my lord.
I have seen the report given back.
This is the report.
Shown to the court,
Only the
for
report
having
is-
perused the report. It is given back to the learned senior counsel.
Yes,
It is a copy of the report shall be supplied to the
in the court.
parties to the proceedings, masking the names of the experts, members of the expert.
my lords, in the meanwhile, could the KPTCL ascertain if these 48 appellants could be accommodated, my lords?
Now, if you make a statement that you will accommodate them, that will be great.
That will be difficult, my lord.
There will
At
be
this
difficulty.
juncture, my lord, I won't be able to do because a fresh assessment will have to be done. The question only is whether what should be the number of people to be considered. Now, my lord, if depending on the result of this case, they'll have to reassess the entire result.
There might be a class of undisputed candidates who are
Please.
entitled to be.
After all, if your lordships are fixing a short date, my lord, it can be disposed of, so that one way or the other, there'll be quietus.
We'll thresh out.
Yes.
Please.
Lordships.
Make one mention, my lords. Serial number 42 and 43. That's the fourth respondent, that's a AICT, which is a formal party, has sought an adjournment. They're not informed. Last time also they took. I appear for the petitioner who has succeeded before the learned single judge. It's a case where we have professors have been relieved, 42 and 43. We are contesting, my lords, but the AICT moves the matter, gets it adjourned, and it's gone beyond. From November, we are without salary. I have to pay family installment, loan installment of 57,000 per month. I'm left high and dry. And now there are other matters before the learned single judge. Because of the stay here, they are moving there for dismissal of those. I'm only saying prior to vacation, if your lordships could accommodate us.
They're urgent. 42, 43 are urgent today.
It was urgent. They were not informed. AICT is a formal party. They have no role. But they have sought time. Last time also they did this. Last time I
appear
kept...
for the appellant in this matter. Lordship had fixed date on 29th of May this morning.
29th of May.
May it's gone
Point
beyond,
number
because
4
till
has
then,
sought,
problem is they're moving the other matters before the learned single judge for vacating. Let them not precipitate those matters.
Precipitate the matter before the learned single judge.
Other matters, because that also
You can't
goes.
take time here and.
No, I did not take. It's respondent number 4. I appear for the appellant in this
But
matter.
anyway, till 29th May, as Mr. Panindra says, justifiably, don't precipitate the matter before the learned single judge.
That's if
You're
that is
not
there.
making any order. Just take time, saying that this is the understanding both of you have arrived at.
May I make one request?
And you want to conduct the case now there.
No, no, my lords, what has happened is, my lords, they have obtained the interim order on the ground that, my lords, writ petition is allowed, not on the ground that, my lords, a writ appeal is filed.
Anyway, we'll
However-
consider on 29th May, we have fixed the date.
Please.
Till then, ask the parties to
But s-
hold back.
Yes, I will not object, my lords, for them taking time before the
Very
learned
well.
single judge.
Then please,
Tomorrow, my lords, let them take time.
please.
Oblige.
Your lordship's kind leave. Lord, serial number 73, I made a mention last week also, Lord, to take it up at 2:30, Lord. It's a review petition. The quarry is going on in the protected forest.
The Supreme
Protected
Court
forest.
judgment,
Not, this is
At
a
that.
protected forest, Lord.
protected forest. 73.
73. If it is not convenient today, my lord, your lordship may kindly have it tomorrow or day after, because
Other
there's
side
been
is there?
urgent.
So the other side is there.
Yes,
for the
sir.
response.
Are you ready today?
We were ready today.
Day after Fourth,
Fourth, all right.
fourth at 2:30.
2:30.
2:30.
$76, 230 matters.
Please, your lordships.
I may produce it.
Only thing is, other day, the matter was stopped at this level.
Please.
That whether this
We are issuing.
issuing corrigendum to extend it to rest
Please,
of the
please, my lord,
country.
decision is taken today, my lord. We
Bow
can-
down, bow down to your lordship's suggestion.
Lord,
Is
within,
just that in this judgment, the Delhi High Court had directed the Election Commission to issue criminal as antecedents of candidates. And the Honorable Supreme Court upheld the directions of the Election Commission, directions of the Delhi High Court.
This was
My lord.
decades ago,
decades ago. My lord, this,
more than 2 decades ago.
that matter went up to Supreme Court,
That
Supreme
went to
Court
Supreme
pursuant to
Court
Supreme
and
Court direction.
And
That's a right to this one only, right
To know the.
antecedents of
credentials of-
candidates. And
Please.
that is attained.
That is very old.
It's, the judgment is only that the High Court is under jurisdiction to issue directions to the Election Commission. My lord, that is my humble submission.
No, no. That matter went up to Supreme Court pursuant to Supreme Court direction, my lord. We
Correct.
should.
But you were to take probably instruction that particular circular would apply to.
No, he
My lord,
said-
I am,
he's saying that.
decision is taken, my lord. The circular we will issue, circular to all the COs of all the states, positively within 2 or 3 days.
In 3 days.
Please.
Next week we'll come.
If they undertake, the matter could be. If they undertake.
Maybe disposed of, my lord, we will issue, anyway, we will issue.
Dispose of.
Please. So which circular you are going to issue to all states? My lord, in respect of the actions to be taken in respect,
We will nationalize it that way. Justice Natarajan's judgment to be nationalized by issuing circular. All right.
oblige. Or should we say in respect of non-cognizable offenses.
That's what, that is chapter 9.
Please, ma'am.
Hey,
Nine
Of the
nine-
IPC. Malad.
9A of the. IPC.
9A.
Please.
Understood, in respect of 9A offenses. Okay.
Syllabus 77. Dean Nagaraj, or I represent.
No, the report has come, Lord, this is regarding CRZ distance criteria. Whatever, Lord, I said, Lord, is, they have been, no, it is correct, Lord. They have 50 meter beyond, Lord. CRZ.
Whether within 50 meters,
Yes.
there are other units of the like nature.
That's I did inquire about that. Methods. There's one unit methods, but that unit falls under the exemption. Prior to 1991, whatever units were being done methods, that unit is an exempted category. Methods may request the report which has been filed by the CRZ authority. Methods.
Appear for response number 4, ma'am. And we permitted to submit the report, ma'am. Report yours.
Yes, ma'am. Put it. That's the report methods. Goes on to say that 50% of his occupation is within the CRZ zone.
The sheds, Lord, where we have given consent, falls beyond 50 meters, Lord.
It is
No.
Page number 5.
That's may start from page number 4, if that's may look.
Page number 5 with the sketch, ma'am. Now, as per 2011 notification, my lord, the entire unit fell under CRZ zone, my lord. Now, as per 2019 notification, my lord, kindly see the line drawn between K and L, my lord.
Is number?
Page number 5, my lord, 5. As per 2011 notification, the entire unit was within CRZ area, my lord.
There are other units also.
No, my lord.
No other unit.
What is this unit?
This is within the CRZ.
As per 2011 notification, my lord, the entire unit was within CRZ area. This is the yellow area, my lord.
In 2019 notification?
The line drawn between K and L, my lord. So now from 100 meters, it is reduced to 50 meters, my lord. So this K and L is the 50-meter line. So beyond K and L, my lord, it's no CRZ zone now.
That even we have stated the same thing. Methods. We are also not disputing that. We are also not disputing. Let's turn to the next page. Those are the photographs produced by the authority. Let's look at the photographs which they have produced. The first photographs mark the 50-meter boundary. The second photograph gives the linear view of the entire building. Now, page number 7 also gives the photographs. Now, our only submission is 50% of the construction of the petitioner falls within the CRZ. Now, that is not something which I am only saying. Let's turn to page number 4.
No, that is not their case, my lord. I'm very sorry to say. It is not his case, my lord, where withdrawing my consent.
Let us understand.
Please. Facts we will understand. Please.
Page number 4, methods. That's the site inspection report. At serial number 1 and 2, CRZ 3 NDZ, that is non-development zone. NDZ stands for distance from HTL, that is high tide line, 90 meters, which methods admittedly is below 50. Number 2, permanent fish cutting building CRZ 3, 24 meters, 590 square meter. Methods, if they are making a statement before the court that we are not touching that remaining, that half building, we are not touching or using it for any kind of fish cutting or any other active fish processing unit, then he's right. We may not have a case, but their case is the entire thing is not covered. That's
So at least 50% is not covered.
50%.
More than 50% is not covered.
Yes.
That goes against you.
No,
You're
no,
saying
I'm
yes.
sorry. More than, I'm sorry, exact 50% is covered.
Yes. So exact 50% is not covered.
Yes. Now, Milords, the question which, Milords, I ask myself is that the way the unit is structured, the unit starts from the prohibited area. Milords, may look at page number 8. That's the entry to the complex. And is that this matter, this very subject matter is pending before NGT also. We are also in a predicament, apart from this. The issue with regard to this particular fish unit is pending before NGT minutes. As of today, that's called out in my objection. I've placed the documents to that effect. In fact, even he's produced one of the orders of NGT. These are facts-based issues, which mean I may not be in a position to read evidence with regard to, apart from these survey reports. Now, there are specific findings, proceedings going on before NGT.
Their party before.
Yes, even their parties
They
before
are also
NGT. Yes, they are also parties before NGT.
Appeal is by whom?
Appeal is, it's not an appeal, it's an original application by a resident of that particular area, in Kundapur, Udupi.
Then this aspect has never come out.
It's come. The same report was, the same report was filed even before the NGT. May take
Same report.
same report. The exact same report, the exact same measurement, except the
Not
sketch.
same report. Report filed before them exactly matches with this report. That way you should say.
Yes.
Huh.
I'm sorry, the report filed before
Lord,
them
may I submission
matches to this report is our submission.
Then
Beyond that, these are my only 2 submissions. I would leave it to my lords and what petitioner has to say for this.
We had passed some orders last time.
Yes. Directing, Lord, the 4th respondent no, to have a spot inspection to inspect, Lord, and measure the distance between HTL and the 50 meters demarcation.
that order dated.
Yes, this is it.
That order is dated 13/3/2020. Sorry, it's on 13/3/2024. Yes, yes.
13/3.
Yes, it's 13/3/2024.
So Director of Environment, UDP district submitted a report
Yes, yes, ma'am.
which was contrary to your this report.
No, it's not contrary. It is correct. It is according to the earlier, whatever measurements there, it is,
Situated beyond CRS.
yes,
CRS.
yes,
Correct.
yes. My 2 units, my lord, where I am operating fish cutting unit, situated beyond 50 meter.
So half truth.
No, full, beyond 50 meter. That's what they given consent to me.
Half truth is more dangerous than truth.
No, kindly see, my lord. Consent
you-
was given to me.
You are for petitioner.
Yes, my lord. 2 sheds, my lord, where I am operating, which are situated beyond 50 meters. With the condition that, my lord, I should obtain a clearance from the CRZ, saying that whether it is beyond 50 or not.
The petitioner herein. Has been carrying on fish processing unit. In survey number 71/6, 72/3, and 72/1B. At Balekudru village. Manga Kakate post, erstwhile Udupi Taluk and district. Now known as Brahmwar Taluk. It appears that the Karnataka State Pollution Control Board had issued a consent for operation of the unit under Water Act in favor of the petitioner. The land on which the unit is being run was purchased by the petitioner under a registered sale deed dated 19/10/21. On 5/4/23, the regional director into environment, UDP district, as respond number 1 here issued notice cum communication to respond number 1 authority, stating that the 2 buildings measuring 240 square meters and 318 square meters were situated beyond 50 meters of coastal regulation zone. Any industrial unit is obliged to maintain the distance of 50 meters to operate near the coastal regulation zone. It appears that the regional director environment gave an opinion dated 5/8/23 stating that the operation of the 2 buildings were beyond CRZ zone. The Pollution Control Board, paragraph, passed order dated 3/1/24, withdrawing the combined consent of operation issued to the petitioner, both under the Water Act as well as the Air Act. On the same ground?
Yes.
On the ground that the unit was functional and situated within the.
Not within the lord, not obtaining CRZ clearance.
On the ground that the certificate of clearance was not obtained from the coastal zone authorities.
Yes, ma'am. It's
Coastal
within
Zone Management Authority, ma'am.
Coastal
Within 4
Zone
months.
Management Authority.
Coastal Zone Management Authority.
Within 4 months.
It is this order dated 3/1/24 passed by the Pollution Control Board came to be called in question in this petition. Paragraph on 13/3/24. This court had an occasion to pass the order after hearing all the sides to find it appropriate to require the petitioner to implement the Karnataka State Coastal Zone Management Authority. The said authority was arraigned as Disciplinary 4 and was further directed to undertake the spot inspection of the unit of the petitioner and to submit report. Paragraph. Today, when the petition came up, petition was taken up for consideration from a learned advocate, Mr. So-and-so appearing for Disciplinary 4 authority, submitted report dated 19/3/24, 18/3/24, forwarded along with letter dated 19/3/24. It states, the report states that the site inspection was carried out in respect of the said unit on 18/3/24 by Deputy Director of Fisheries, Office of the Regional Director, Integrated Environment, UDP. The observational figures in tabular form showing the distance of the building, etc. Building, temporary cement sheet, etc.
From high tide line.
From high tide line were indicated. Full stop. The report paragraph. Also attached with the report are the photographs and the maps which show that the substantial part of the building of the unit is located within and falls within the CRZ.
No, beyond 50 meters. Beyond 50 meters.
We are concerned with what is within.
Beyond 50 meters.
You are concerned with outside. The report reads as under in its final finding, page 3 of the report, however, as per the CRZ notification.
Make one some
In that view, prima facie, in the above view, what is obtained prima facie is that the unit is functional, at least in its substantial part, within the prohibited area.
No, I'm sorry, no, not even single feet, we are utilizing. Beyond 50 meters, the two sheds, next.
Substantial part.
No, we are not using CRZ.
We are saying about what?
Not even report also, report also, their report is.
In part, not.
No, not part, not even single feet you are using. Not even single feet.
Partially.
Not even partially, two sheds, kindly, I will show, I have produced the same map in my petition.
To some extent.
Not even some extent. Not even some extent, my lord. 240 square feet, my lord, shed beyond 50 meter.
Next.
To some extent.
Lord, ma'am, sorry, my lord. The consent was given to me for 240 meters, which is beyond 50 meters as per their own report.
The report has come now. Report is some saying. We understand that. We may be wrong also.
No, kindly, I will show you, my lord. Kindly see the page number 5, may kindly see, my lord. Page number 5, kindly see. Not even single feet. Right side, kindly see. Red fish cutting building 24 meters. Within 50 meters, 350 meters. Beyond 50 meters, 240 square meter. That is my shed. Beyond 50 meters. Then next kind is cement sheet roofing. Beyond 50 meters, 31 square feet. I am not using even single feet. Entire thing is beyond 50 feet. That is their case also same, Lord. I am not saying that. It is their case also. Because of this case, they have given consent to me.
While we have noticed the contents of the report as above, from a learned advocate, Mr.
Mahesh Chaudhary.
Mahesh Chaudhary for the Pollution Control Board stated that the very unit, the very issue in relation to the petitioner unit itself is pending in a different matter.
No.
Before National Green Tribunal,
Chennai.
Delhi,
Chennai.
Chennai. He also submitted that before the National Green Tribunal also, in the said proceedings, report containing similar contents
Yes.
was produced. Since the subject matter involving the similar controversy is pending before the National Green Tribunal, and the parties have been contesting the similar issues before the tribunal, while adjourning the present proceedings to a next date, this court permits the State Pollution Control Board to produce the report dated 18/19/24, produced before this court, to place on record before this court, to produce the same before the NGT as well, and seek appropriate orders.
Lord, I should be given some, sorry, Lord.
What
I'm
is
very-
wrong in,
No,
what is wrong in
I
this?
am not, kindly see, Lord, kindly see, I just point out two aspects. Not in NGT, Lord.
If you are here, this side, then you would state the operations.
No, one submission, one submission. Kindly NGT order, NXDF, kindly see forever. 2 minutes, because I am not given. Page 50 of my petition copy. Kindly
We
see.
are only requiring them to produce this.
No,
report.
Lord, but now the order impugned is not available to the NGT.
No, we are not making available.
Lord, now I have to challenge before, because the appellate authority is not functioning here. I have to come before the sample court. There is no authority, otherwise I can challenge this order.
We don't read for seeking appropriate orders for information of the tribunal.
From my submission, kindly, one submission. NGT has passed order on 29th September 2022. There, Lord, NGT has said, kindly, Lord, bear file.
Yes.
Kindly see, Lord, page 65. The Pollution Control Board, kindly see page 65 of my 65 of my petition.
65.
Yes. Point number 3, where, Lord, we are a party, we are all party there. Now, kindly see the point number 3, the Pollution Control Board, page 65, NGT order, operative portion. Point number 3, where we are all party there. The Pollution Control Board is advised to be cautious before issuing any CFO, particularly in CR zone. Now, kindly similar on thereafter, I was given consent. Page number Annexure C. Annexure C. Page number 30. There I was given consent.
Page number?
30. Annexure C. And thereafter, I have this petition was given consent for 2 sets. That is on 14/8/2023. Valid up to, kindly, I will just, my lord.
So that only a part of the wall is inside the.
Not the wall, my lords. It's not the wall.
It's a
It is
common
the-
building, my lord.
It is a common.
Did
building. They are trying to, my lords,
Common building.
they are trying to make a fish, sorry, piecemeal, my lords, saying that
Very
this
sorry,
is
my
not
lord, I just,
working.
I'll point out, my lord, kindly what happened, my lord. I am sorry, my lord, I'll point out, my lord, what happened. There is a building, my lord, existing in 1965, 70, not now. It is a building constructed in the year 1970, it is there. 50% of that building, my lord, falls in the CRZ zone, remaining 50% falls in the non-CRZ, non-development zone.
Outside.
Outside. There I am carrying. They have given permission to me. Annexure C, kindly see me for a while. Annexure C, they have given consent for me to operate the fishing unit,
Can't be.
2 sets, my lord, beyond this CRZ zone. It is their case. Kindly see the page number.
This is
Annexure
like-
C.
This, my lords, is like making a
Very sorry, my lord. They have given consent, I produced Annexure C.
statement, my lords.
Kindly see Annexure C, kindly for.
Percent.
Very sorry, my
I-
lord. He cannot argue like that. Annexure C, thou notice, David.
We are not touching anything. Your operations, we are not touching.
But I am not carrying in CRZ note, CRZ.
We have not opined anything.
Consent has been withdrawn now. I have been stopped from
Yet
carrying out.
the petition is pending. We'll consider. We are not adjudicating anything except noticing the report. And that too, we are not expressing anything about the report.
Now,
Yeah.
my lord, report is in my favor.
If any observation which are dictated against you,
No,
we'll
Mr. No, sir.
delete it. We'll only say that the report is on record
The one submission.
pursuant to the last order.
Lord, with great respect, my lord, I'm great respect.
The
my lord.
operative portion will quote and we'll say
My
that.
lord, with
since
great
the-
respect, kindly
This
see, my lord.
shows that
Since
No, I am
the-
sorry, my lord, very
not
sorry.
want to go
My lord,
before
my lord, kindly
NGT.
see, my lord.
He does not,
Kindly
he
see,
does
my lord,
not
very
want
sorry,
to
my
go
lord,
before
let me
NGT.
not implicate. I'm very folded hands, I am praying, lord. My lord, my two sets, my lord, falls beyond 50%, 50 meters, beyond CRZ note. They have given permission to me.
We are not giving any finding in that regard.
Therefore, my lord, now the report has submitted is in my favor.
Very good then.
Then my consent order has to be stayed now, withdrawal order,
So your report in favor, let it go.
in
to
my
the
favor.
Tribunal also that it.
No, my
may-
lord, there, my lord, this order, I cannot challenge there. This order, my lord, is, no, I cannot challenge there.
Tribunal also will see the
No,
report
my
in
lord,
your
this order
favor.
has to, I cannot challenge there, straight away. Kindly annex the C for a while, my lord. Kindly see page number 30, my lord, 60 women are working there.
Today we can't decide the petition finally.
No, my lord, I will take, my lord, I am pressing for interim order on the ground, my lord. Whatever report filed by the fourth respondent is in my favor. Very sorry, my lord, very sorry, this is not correct, my lord, very sorry.
don't-
Page number 30.
I don't know
Let us see
who's
report
he
is
saying
on-
not
Annex
correct,
the C,
my
my
lord.
lord, annex the C. I will show, my lord, how.
Saying Not
Yes,
correct,
again.
not correct, without even
Annex the C,
speaking a
kindly
word.
see.
Mr. Chaudhary, let us see whether report in his way or not.
My favor, my lord, I am showing.
Yes, my lord. May make a
Annex
submission.
the C, kindly see, my lord.
See, temporary cement sheet roofing 63 meters. Permanent fish cutting building 24 meters.
My lord, kindly see, my lord. Before that, my lord, annex the C may kindly for a while. And a consent which was
That
given to me.
Pollution Control Board
Certificate.
certificate it is.
Yes, they have given permission to me, kindly see, my lord, now.
That's true. But now NGT advised them to be very cautious. Therefore,
Thereafter, they have given to me.
therefore we have called. a
After NGT advised, my lord, they have given consent to me. For, it is for two sets, kindly say, I have produced the same map also, I have produced in my petition, same lord. I am also relying the same map which they have produced.
Now
How much?
you are facing notice also by the Coastal Zone Management Authority.
All those are
My lord,
pending.
my lord, kindly see, my lord, I will
They are
convince,
facing
my lord,
a
my
lot
two
of
sets, my lord, nothing to do
multiple
with CRZ. I will
litigations.
show, my lord, I will show you on the face of it, no, kindly.
PI is
Annex the C,
pending
my lord.
before this court.
No, annex the C for a kindly word, kindly see, my lord, annex the C.
Let us. Annex
See,
C.
government, annex the C, consent was given to me after NGT order. Page number 30. That is dated 14/8/2023.
It's here, it's here.
You know, this is valid from 20th July 2023 to 30th September 2032. 2032 validity, page 30. Now kindly see, my lord, page number 33.
This is what is suspended.
No.
No.
This is
This is
withdrawn
what
now. This is withdrawn.
This is very.
Yes.
It's in effect the same.
Kindly see, my page 33.
33.
Yes. There, my lord, single line matter is there. I am reading, my lord, the similar conditions at page number, sorry for the input, page number 26. Similar conditions have been quoted at page 26.
The same report is duplicated here. This you have duplicated or what is that? This is identical. Your certificate-
Same.
If you permit us, we can do that. If you do not permit us, then we are helpless. We have
Sorry,
to
sorry.
be mute spectators.
Sorry,
So We'll
sorry.
sit up to 5 and go
Very
away.
sorry, sir. Very sorry. Extremely sorry.
Whether these factors are duplicated in your report,
No, my lord.
page 41. What he is saying is,
Yes, my lord.
after seeing the identical factors,
Yes, my lord.
the certificate has been given by the Pollution Control Board, which is now suspended,
Yes, my lord.
is his grievance. The factors that appear at page 41,
Yes, my lord.
do they figure in your report also
Yes, my lord.
verbatim?
Only the sketch is same, my lord.
Huh?
Only the sketch is same. This part inspection was made on 18/3 as per the directions by this honorable court, my lord.
Suppose if 50% of that, if he does not work at all in the zone, but outside if he works, do you have objection?
He is
That's,
saying, probably he is saying that only rooftops.
That's only this.
That's,
But
I'm
anyway,
only,
if he
I'm only
says-
saying this, my lords, that, my lords, we can't keep with monitoring itself, my lords, it is getting so difficult to see them not to operate within the CRZ zone. Now, my lords, if by saying that in a room, half I'm not going to touch, only the other half I'm going to walk, he has to walk through that CRZ zone. He has to take the material through that CRZ zone. He
Not
has to
correct, my
cut.
May I make a submission?
Even
here?
in the sketch,
My lord, as per the sketch, my lord, the portion which is shown in yellow color. So this 100 meters was NDZ zone as per 2011 notification. 2019 notification. The
Now
entire,
it is 50 meters.
now it is 50 meters. As per 2011 notification, my lord, the entire structure came within the development zone, my lord.
Non-development zone.
Yes. So in June 2018 itself, we issued a direction under section 5 of the Environment Protection Act to demolish the entire structure. Now that has been assailed by the petitioner in writ petition number 27462 of 2018, which is still pending before this court, my lord. Now the petitioner is claiming benefit,
Where here they should.
a direction to demolish.
Milord, may I, on that I'll
other
state.
PIL also.
Milord, on that I'll make submission.
Before
Milord.
this court, concerning the same unit, my lords, we are looking at multiple.
Milord, very sorry, Milord, I am making.
By
a-
the petitioner itself.
Your report is in fact not that
It's not,
precise
50%.
in giving opinion. Page
Now-
3
Now, my lord, the petitioner.
says that without prior approval of the, without prior approval is a violation.
Yes, my lord.
Very catchy. What is violation? Without prior approval.
That's all.
Yes, my lord.
That's all. That's the only the events.
That's
So-
the,
And you are saying again that the coastal zone management authority has issued notice under section 5. So the violations are not established. Does it established?
No.
My lord, we issued.
At least in your report, does it established? If it is so, then you should have issued notice about closure or discontinuance of the operation.
My lord, we issued direction to demolish the structure after giving him an opportunity to give reply, my lord.
In that, that is challenged in another writ petition.
Yes, 27462 of 2018.
There
my
is
lord.
interim order.
Yes, my lord.
Therefore, stay of demolition.
Stay the operation of the order. And one more writ petition has been filed by School Development Committee, my lord. And
That
one-
is stayed also.
Yes, my lord. And one more writ petition has been filed by the School Development Committee.
PIL.
Yes, my lord, which is right next to this fishing unit. Writ petition number 12005 of 20. That is also pending before this court. My lord.
Then all will club together.
all will club.
All
I think
will
that
club
is
together.
before single bench.
Lord,
my lords.
may I
The
submission,
one
Lord?
writ
No,
petition
point is,
before
Lord,
single
with
bench.
great respect, Lord. The point is, Lord, whether the two sets where they have permitted me to carry out situated beyond 50 meters. That is the point. Both the reports now tally each other. Kindly see, Lord. Both their maps are same maps, sir.
But in cognate petition, some interim order is operated
Yes, my lord.
in your favor.
Yes, Lord.
Then why?
I may be permitted to carry him, Lord. This is not going to harm them. CRZ is meant for fisher community.
No, it is not meant. for
CRZ,
fisher
the
community,
very
it's
policy
meant-
behind CRZ notification is
It
to
is not.
protect the interest of fishermen community. I am a fisherman. I am employed for 60 women.
So it is a bit mighty larger.
My lord, there is a lot of allegation against this unit for causing pollution, my lord.
So we'll post it, give the numbers of all the
Give that
connected.
Yes, my lord, I will.
We'll post it on
There are
fourth,
report 6 to 7 matters of this nature.
fourth.
Please, please.
Third. Fourth
There
will
are-
not be, maybe third, third or eighth, my lord.
Third may not be possible. Third may not be there.
Or
Fourth.
why not fourth?
Fourth, I'm ready.
Personal inconvenience, my lord, on fourth and fifth, my lord.
Fourth and fifth person. Eight.
That's my.
Lord, these
Probably.
60 women, Lord, who are working, Lord, on daily basis, Lord, their livelihood has been taken away by, Lord, arbitrary action, Lord. Lord, my situation,
We were here along with those two matters. Wait.
Lord, there are other several matters where, Lord, similar CRZ.
No, no, no.
Lord, where
Not
he
with
appears,
regard to
sorry, my lord,
petitioner.
very sorry,
Now,
where he appears.
Why is he?
your friends are being agitated by seeing
Yes.
their faces. We can make out they are agitated by your arguments. We are not.
Lord, I am,
We are
Lord,
our
I am on
duty
the
to hear,
facts,
we'll
Lord.
hear you.
Lord, I am what to
But
protect
leave
my client's
what's-
interest.
What prompted you to all of a sudden with
That's, we had given a timeline of getting the consent or the CRZ clearance. That's 4 months got over. Then we acted upon it.
No, on the same factors you have given, page 30, your certificate is given
Yes.
on identical
That's
factors.
on the
All of a
identical-
sudden, how things will change?
That's, yes, that's the intervening circumstance was also that, that's the orders by the NGT, that's which I will point
And
out.
you are
That
also-
order, after seeing that order, you have issued
That's
that.
pursuant to which there was another proceedings which is pending. That's as of today, it's pending. That's my habit on it, all the petitioner.
We'll call this matter on 8.
Yes,
Things
madam.
do not seem to be that simple.
230, my lord, 230. Lord, 230, my lord. 230 on 8th.
Oh, you can dictate.
I
so
am
many things
requesting,
to us.
I am requesting, please.
Wait,
I am requesting, please.
230 meters are only those we have to be dismissed.
I am requesting, please. Please, oblige me. 230. Oblige me, oblige me.
Grateful.
Number 4.
And for the petitioner.
Not in this matter. It's sought for instruction. Temporary registration is, there's no provision.
No provision.
No provision. They may register regularly, my lord. Thereafter, subject to the
Kindly-
decision of the apex
Please
court.
wait. Why are you
Please,
so much
Please, I'm
tempted?
sorry.
You should resist your temptation.
Please, I'm sorry.
Subject to the result, my lord, they can migrate it to the PS series. There is a provision, my lord.
Subject to outcome of the PIL,
Outcome of the PIL.
SLP,
Yes, sir.
SLP.
Yes, sir.
That appears to be,
May I take your lordship to page number 5. Under sub rule,
registration. They can do the regular registration itself, subject to outcome of the SLP. So that everything will be
That's-
over. Because they have succeeded in that litigation.
let them register it.
I make the submission.
Even when we want to be with you, why can't you learn some advocacy?
I'm sorry, my lord, that is not,
We are going to give
I'm sorry, I
registration.
thought you had concluded. I'm sorry. My apologies. My apologies.
Please be
sorry.
seated.
I'm
Please
sorry.
be seated.
May I take your lordship, my lord? Page number 5.
More than that, we will not say. Now, in this contempt, how we want to structure the order is, the contempt is in respect of the judgment. Judgment is put in SLP. SLP is pending, no orders are passed. Now, subject to outcome of the SLP, you have to give regular registration because the rules do not provide for, even according to you, temporary registration. That you have to do,
Regular
unless he
registration,
comes in the way of our giving such an order.
regular registration, we have no objection, lord. Thereafter, lord, if he succeeds in SLP, if he
Not
fail,
he, you have gone in SLP.
yes, lord, if he fail in SLP,
Well,
then he is entitled for lord, BS series. BS series registration.
Subject to.
Sub-rule-
Yes. Outcome of the SLP.
Sub-rule 3 provides for that, lord. Page number 5.
Unless SLP is decided, what we can do.
That's exactly, but that was my anxiety in submitting earlier. To his submission, the temporary registration is not possible, is not correct at all.
So
Kindly see
regular-
section 43 of the act. It is a central act.
Good.
It was redone in 2019, where there is no bar now to register beyond 1 month.
Kindly consider the first hurdle in these proceedings of contempt is that there is no direction. which we can ask them to comply.
Please.
Still, however,
Judgment we are doing.
since there is a judgment of the court and the learned single judge held in your favor, we are of the view that whatever decision is taken by the Supreme Court in SLP, they will bind. They'll comply with this direction.
The difficulty is this. With, kindly see.
Today, there is no direction which we can ask them to come to act upon.
In fact, there was an earlier direction also, interim order was also there by the single judge, which
All
they have not
all
complied with.
merged, all orders early. All merged, all earlier orders, including the order of learned single judge, merged in this appellate order, where there is no direction. You can file a whatever, but
Not this
in
specific
contempt, we
provision.
can't help.
My submission is this. Section 43
Till we are
provides for
ready to
temporary
say,
registration.
still we are ready to say, since the council is saying that they will abide by the outcome of SLP and implement the order.
Please.
No?
We will register in regular registration,
Regular is.
regular registration, not BS series.
And
As per this notification,
temporary.
notification dated
So that is
14th
better than-
December.
Section 43.
Kindly see section 43.
Lord, yeah,
A moment, look into, because for his satisfaction, we can't send them back saying that we don't want to look into the law. Everybody is after law, therefore you have to look into the law. Read section 43, it begins with the heading, what he has said now. Provides for a temporary registration. If law says we cannot deny citizens merely because of some pitfalls in the advocacy, we can't prevent
So
the
you are
litigants
going to
taking the
give
fruits.
temporary registration?
Provides for temporary registration.
It will be subject to outcome.
at 1 month, we have already registered, Lord, earlier. Earlier temporary registration was done for a month. That cannot be done for successively.
You continue, otherwise implement the order. Instead of that, go for temporary registration, subject to outcome of the SLP. That's what my lord also felt. It provides for temporary, you said, there is no provision for
No.
temporary registration at all.
Initially,
There is.
we have issued temporary registration for a period of 30 days.
Then thereafter, what should happen?
30 days, Lord, then.
Renew it.
Only,
Otherwise, he will be put to injustice.
Lord, as per proviso, it is valid for only 30 days.
Now,
Please.
because your matter is pending and no stay is granted, can he be asked to wait indefinitely?
No, that is why.
Do
we are
it,
requesting,
and
Lord.
subject to whatever apex
We'll
court
do
will
it
say.
in a regular, it will not prejudice the interest of the petitioner, Lord. We will do it in a regular registration.
If he does them in regular
Then, Lord,
stream.
thereafter, the act provides, there is an amendment on 14th December 2022, Lord, which I have produced now, which provides, if at any time, owner of the way registered in regular series of any state or union territory become eligible for BS series as per clause CA or CB of sub rule 1 of rule 47, and the owner of such vehicle opts for registration mark in BS series for such vehicle, then owner of such vehicle shall apply in form number 27A for assignment of registration mark in BS series to the registration authority of the state or union territory in which such vehicle is currently registered or placed.
If regular registration is given.
Difficulty is, my lord, I have no difficulty with it, in the sense that here in Karnataka, lifetime tax is taken. In this particular vehicle, my lord, is about 27 lakhs, is the lifetime tax. Now, would they give it back with interest, or should I, for the sake, just because of their convenience, should I come out with 27 lakhs just because it is convenient to them, when there is actually a rule which provides for temporary registration?
It's for 30 days.
No, my lord, earlier it was so. Earlier there was a specific bar that it can't go beyond 30 days. In 2019 amendment, it was changed. Kindly see the new, the 2022 15th edition, my lord, what I have. In fact, the earlier section is also reproduced here. Earlier proviso second said, a registration under this section shall be valid only for a period not exceeding 1 month and shall not be renewed. That was struck down in 2019. And this particular current section is there, which says 30 days. There is no bar as such now. There is a reason that proviso was taken out by an amendment. So they're saying that it is not, temporary registration cannot be provided, may not be right.
Will differ. But you also think it over their proposal. They want you to insert in the pipeline. And if by granting regular.
Then a clarity should be given whether, how the lifetime tax will be refunded to me. That again, there's another complication. That's my worry. That's
And you also check up whether this proviso newly inserted can permit
Please,
repetition of this.
Please continue, renewal of this, another 30. Otherwise, the
So
entire
far as-
lifetime tax has to be paid.
Yes.
Please. So far as tax issue is concerned, that will be adjusted to be a series.
You just
Whatever is
have a
there.
word with your department and come back with the proposal.
Find out some solution because.
Please.
Can you have it on Monday, Mala?
Monday. Monday.
Publish.
Kindly. Item number 52. Was listed on 27th, my lord.
For a viewer of the, at least I was under impression that we'll be able to complete the entire code today. But because of that matrimonial
Family
matter.
matter took lot of time.
Yes.
Your lordship said, just 1 minute, ma'am. On 27th, your lordships allowed my application for amendment and gave him liberty to file additional statement and for me to file a amended petition. But the order sheet does not show it.
It will be available.
Lord, in
Kindly,
this-
that may be incorporated.
In this matter, Lord, earlier I raised. a
No, other day we remember.
Yes.
That's
An
true.
order was
I am
made
not
while
disputing.
going.
it. I am not disputing. Lord, earlier to that, I have raised a preliminary objection with regard to the maintainability of the petition on delay.
That
Delay.
is on merits,
That
my
was,
lord.
that was recorded by this honorable court, Lord, in one of the orders. Lord, for which he sought for time to file an affidavit explaining the delay. So far, it has not been filed.
No, that's all.
File,
On-
file.
On delay,
That will go to the root of the.
very well. We'll do that. But amendment, therefore we permitted to file additional statement of objections if you so desire. But that order is not printed is Mr. Rao's grievance.
That may.
41, my lord, 41, sir. 14%. Is not reached.
Professor is waiting for which? 17. 70.
These are COVID warriors with
In this matter, we have preferred two writ appeals, not the writ appeal number 276 of 2024 and
Against the
440.
very same order.
Very
Then we'll
same.
call that writ appeal along with this matter
That
as we are doing in
Yes,
the regular court.
yes.
41, sir, 41.
Now will be distributed. Every.
That's all.
Lordship's permission. The Lordship's permission, my lord, serial number 58 pertains to the BWSSB, my lord.
So handed over to Leonard.
What, if it could be taken on 15th,
58 series matter.
yes, ma'am.
But in that case, I appeal out for some of the appellants.
Service is incomplete as it.
Yes, my lord, there is an order of stay granted by this honorable court. My lord, we are not able to continue with the work. My lord. That is the problem.
But at least to ensure the service happens so that we can take up the matter.
Petitioners have to be, they are not doing it. It's an appeal.
15th of.
One indulgence.
41, sir, 41. Serial number 41, 41, sir.
Date will be given by court.
Serial number 41, interim order may be extended. 41.
Yes.
Very, very.
41,
I was supposed to mention.
44, my lord, requesting for a date in this.
Date will be given. date of, not of your choice, but
In this week.
nearly of your choice.
Serial number 48. Lord, there was an order for them to.
It will be distributed subject to the length of the